Good morning and welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's calendar, and the first one is 25 CV 669 Gallo Holdings LLC, Series 1 et al. Versus Andrea GRAYTON. Whenever you're ready, counsel.
When Your Honor, may it please the court, Michael Forster on behalf of appellants. I'd like to reserve 5 minutes for rebuttal. Your Honors, this is should be a very simple case about a non-payment. It's a habitual late payment claim. The appellant filed for a notice to quit to the appellee be due to the many late payments she had made. That there was 2 different notices to quit. The notice to quit that the court relied on was issued in November. Was issued in December, with payment required to be made by February 1st. And in the intervening months, there were 3 payments that were made by the appellee. There are 3 payments that were credited to the appellee. She made 2 rent payments that she marked in her own words, October, November rent. At the time of the notice to quit, she had owed about over $5,000 in rent. And she elected with that payment to have that payment go towards her arrearage. And we've provided Supreme Court precedent granted from the 1800s, which appellee has not disputed, that showing the payor's election matters.
Which payment are you talking about? Are you talking about the stay DC?
I'm not talking
Okay,
about the state DC payment yet. I'm talking about she made a $1,600 payment in December, to 2 money orders totaling $1,600 that she marked October OCT./NOV-2021. So she put on the money order. It's in the record, the first exhibit in our appendix, where she elected for that payment to be towards her arrearage.
And at bottom, you're basically, your dispute with Judge Ricard is he's just like, let's add up the money that came in to you on behalf of or from Ms. GRAYTON and see, which months it covers, right? If the landlord is getting this money and it's covering these months of payment, what's the problem?
Well, we have multiple disputes with Judge Ricard's decision. But the problem is the intent of the parties and whether she took an action to cure. Now, so I can turn to the state DC payment, which has been in dispute. It was clearly intended for May, June, July of 2021 rent, which we have.
May, June, July? Didn't you say April?
Or April. I'm sorry, April, May, June. And regardless, it was 3 months prior.
Okay, and can you clarify what is in the record on this? And there's something I saw somewhere, either attached to a pleading or actually in the appendix that looks like that check, which doesn't have anything on the memo line, but you seem to be saying in your pleading that there is something on the memo line. Can you clarify the record?
Yes, there is something clearly in the record, and we didn't call the attention in the briefs. But Dependents Exhibit 3, which was filed with the court, and I'll rely on Rule 30 to say, even though it wasn't in the appendix, we'd like to rely on it. It's a text message between the parties, where the plaintiff or the appellant was asking about which months the rent assistance was going to be. Ms. GRAYTON replies 3, May, June, July. Thanks. I believe they only allow 3. So this shows she was applying back in the spring of 2021. She was applying for those 3 months, and then it was finally paid.
No one disputes that, really. That's where it came from. But why does that mean it can't? Who knows what happened to those back then? And in fact, there seemed to be reason to believe, at least there's no. What is the evidence that she hadn't paid those months by the time this matter arose?
Your Honor, there are 2 pieces of evidence. Number 1 is the notice to correct, which itself lists over $5,000 owed as of the time of the notice to correct. The second is the ledger.
Does it say what that 5,000 comes from?
No, Your Honor, it does not. It does not say which, what months are from which.
Okay.
And there's also the ledger that was not disputed at trial, and that's in the appendix that shows that there was clearly a balance. And
Sorry, just tell me where in the appendix and what you're trying to point me to.
I'm pointing to the ledger, which is
All right, I see. I think it's at page 7. of the
page 7,
appendix.
page 7 and 8.
January and February 2022 and
March 2022.
what are you trying to draw my attention to?
The fact that as of January 1st, there was a $5,392 payment, balance owed before the
I mean,
state agency payment came in.
There's also these late fees involved that for all I know, that I think the trial court disallowed. For all I know, these are made up of late fees over the years that were disallowed. I mean, they don't tell me that this is back rent from April, May, and June. For all I know, she's made those payments. State DC then issues a check and she can apply it how she wants to future rent, as sort of what the trial court said. And I don't, where's the testimony that she still owed April, May, and June? Where's the evidence of that? I mean, you want me to discern it from a ledger that is totally nondescript? It just has numbers. It says, this is what we think you owe. I don't know what you're basing that on. Maybe an annual fee of, something that's totally unjustified is for all I know where those numbers come from.
Well, it was testified to at trial, and if we need to motion to reopen the record to get the transcript, we're happy to do that.
What do you think was testified to at trial?
Mr. Gallo himself testified to where the state DC payment was for and what the rent was due.
It's the appellant's burden to provide the record from which we can make our decision.
That's correct. The appellee's own brief lists the same number in their statement of the case of 5,361 as the amount owed.
Well, because that's in the complaint, right?
Correct. Well, the complaint was not a non-payment of rent case. The complaint was habitual late payment of rent. The notice to quit lists that number. The complaint itself references that there have been 3 months of non-payment. But Your Honor, even if you rule that these payments were going to be, well, additionally, I'd say that, state DC, if we're going to take Judge Ricard's opinion, it's that the government was paying for 3 months that hadn't occurred yet. And that's not how the government works. That's not how state DC works, that she could have moved out and they would have paid for a room that she didn't live in. But we don't even have to get there if we properly analyze the Borger decision. Borger requires a fact-sensitive inquiry whether she has effectively cured. Borger was about someone who had noise complaints, and for a couple months they didn't create excessive noise, but then over a period of months after, they did so.
Didn't Judge Ricard really do a very fact-specific inquiry? He's like, you add up all this, you're saying even if the state DC payment is fine. So you add up all these payments, that gets you basically through March. She pays April 8 days late. May, the registry is being set up and she's holding it for that. And he finds that that's not late because there's a reason for that. So there's basically one 8-day late payment. And he's saying, I'm just not going to find that that's enough to determine under Borges, or is it Borger? Borger, that there's what you call recursion.
Well, Your Honor, he says she objectively cured February 1. And appellee uses that February 1 date to say, okay, she's cured, we're done, we don't need to look to anything else. But this is habitual rent payment. This is habitual, needs to be over time. And I'd argue that if she's somehow found to be current by February 1st, not paying on time, and March was not on time either. If you run the math, and you're most generous towards appellee's payments, she's not current on March 1st either.
Well, I was being generous toward the trial judge's, the magistrate judge's assessment of the payments, and I didn't, what is wrong with his assessment if you include the stay DC that then March was already covered?
Well, he basically, my reading of his ruling is that the March payment, that he doesn't even get to March because February 1st, she had objectively, he used the word objectively cure, which to me makes it sound like he ended his analysis. And she paid late in May based on the court registry requiring her to pay. There was a pending motion, but she was still required to pay May 1st on time. There shouldn't have been any confusion here. There was no reason for her to be late. This was a willful decision to not pay on time. I believe I am out of time.
Okay, and did you say you wanted 5 minutes for rebuttal?
Yes.
Okay, we will give you that.
Thank you.
Thank you.
Good morning, and may it please the court, Fran Swanson for appellee Andrea GRAYTON. I'd like to start with redemption because even if the landlord was correct about any of the cure arguments, they have no basis for reversing the trial court's determination that Miss GRAYTON paid all the rent that she owed by the time of trial and therefore had redeemed. That's at SA 24 to 25, and the landlord has never disputed those facts. Pritch says that's sufficient in a habitual late payment case. Quote, since Translux procedure permits redemption notwithstanding a tenant's default, it is no less available to redeem a breach of the obligation to pay rent on time than it is to remedy a breach of the obligation to pay rent at all.
Are you just are presenting this as the easiest way for the court to resolve this case, or do you think that that's your strongest argument?
I think that both the cure and redemption are equally easy for the court. Turning to the discussion that you all were just having about the cure, the landlord has to run the table and establish that none of the 6 months of rent that Miss GRAYTON paid or caused to be paid during the cure period could possibly be counted toward February 1st. And they just can't do that. There are the 2 payments that she made in December. There is the stay DC payment that was made on January 7th. There's no evidence in the record that had to be attributed to prior months. The landlord is simply incorrect in asserting that stay DC payments cannot be paid forward. We know that's a pandemic era program where many tenants were in Miss GRAYTON's situation of waiting, in her case, 6 months, in other cases, well over a year for the government's payments to come in. And so any of those are ways that the court can easily resolve this.
I have been wondering what it means to cure when the violation is late payments. I would have thought that where there's a history of late payments, the cure should include anyway, the payment of interest for the periods in which the landlord had to wait was there to get paid. Was there any thought given to that? Did anybody ever argue that what she's got to do is pay interest for the delays?
No, the landlord has never argued that. Pritch, I think, squarely answers the cure question. I'm happy to address that, and then I can maybe talk about the harm to the landlord that your question is getting at. So Pritch is very clear. I believe it's at 803 of that case. The court said the way that a tenant cures in a habitual late payment case is to pay timely the next payment that comes due after the 30-day notice period expires. And that's exactly what happened here when any number of the payments we've been discussing.
It just strikes me that's odd. That's hardly a cure. That just says the tenant raises her hand and says, well, I'll do better in the future. But that doesn't cure the late payments in the past.
So the landlord could try to remedy any harm caused by the late payment.
One argument is she overpaid, so she actually did pay it.
Yes,
I
of
got that
course.
part,
Mhm.
but
Yes.
nobody's made that argument either.
Right. So the landlord here has not argued, has not made this cure argument, but there are ways for the landlord to try to be compensated for any harm caused by late payment. So for example, the landlord could sue for breach of contract and argue consequential damages. The landlord could also attempt to seek late fees, but Pritch is very clear that you cure by making the rent payment owed because that was the lease violation. I'll also just say that, you know, landlord tenant law in the district accepts that landlords can be made whole by payments that are made late. A couple of examples of this. So Translux itself says that a tenant can redeem up until the point that the marshals are at their door and they hand a check for the rent owed to the landlord. That's by definition always going to be a late payment. In some instances, years of late payments. And
I think, maybe I'm getting Translux confused with another case, but I think interest is actually talked about in those circumstances.
yes, Translux itself
Yeah.
does mention payment of costs and interest. We know that just seeing thousands of these cases a year, that does not happen. But the landlord has made no argument that she didn't redeem here or that there were interests or costs that were owed. Another example of that, though, is the classic protective order payment, where a tenant is paying into the court registry and the landlord does not receive that money until the end of trial. A final example that I'd point to that frames how we should evaluate financial harm is the district eviction law itself in non-payment of rent says you can't evict someone if they owe less than $600.
So can you just tell me, and this might be getting to Judge Glickman's concern, what is a landlord's remedy if a tenant's, let's say express position is, I'm not paying you a dime until the eve of any eviction. But I'll make amends then. Every time you try to evict me on the eve of eviction, I will pay everything that I owe, but not until then. And there's just a cycle, and this is the tenants has a habit. This recurs several times, and every time avoids eviction, and then says, "And now you're going to have to wait until you get back to that final step again before you get another dime out of me." What is the landlord's remedy then?
Under Translux, the law of the district says that's permissible. The landlord could, of course, sue the tenant on contract to argue consequential damages as a result of that pattern. They could.
When you say that's permissible, you mean, yes, you can successfully avoid eviction in perpetuity through that somewhat fanciful design.
Yes,
Okay.
the tenant can redeem.
Understood. But maybe a contract claim that the landlord has, although, they would need to show some consequence of not having that money at their disposal during the interim.
Right. And, while we're talking about the potential economic harm that landlords might face, I think it's important to situate this conversation within the facts of this case. So as Magistrate Judge Ricard noted, Ms. Grayton lives in this unit under a lease that she won in a settlement agreement in 2006, and she won very favorable terms under that lease. Mr. Gallo in 2019 decided to purchase her unit, among others under that settlement, bound by that settlement agreement, for an extremely favorable below market price. And this is why the unit was priced as it was. And so ever since then, he has been trying to attempt to evict Miss Grayton because she is under this favorable lease. And that's, of course, why he would choose the habitual late payment route and try to argue to this court that she cannot redeem because she has paid all the rent that she owes and he wants to get her out of the unit.
Yeah, do I understand correctly that there were really two claims that he was asserting. One was for back rent and the other was for the late payment of rent. Do I understand correctly that in July 2022, there was a settlement agreement and she paid essentially all the back rent that was owed, and he zeroed out, he being the landlord, zeroed out her debt, so that by the time we get to this case and the end of the 6-month period, she owes him nothing. When she's paid, paid her what she has to pay for the late payments. Is that right?
Yes. 2 trial court findings on that. She redeemed in July of 2022, and at the date of trial in November of 2024, she had also redeemed. That's SA 24 to 25, and the landlord has never disputed those
It's a
factual.
little hard under those circumstances to see how he can argue she hasn't cured. She doesn't owe him anything.
Right, she has certainly redeemed under
She
the.
then makes the next payment on time and.
Yes, precisely. And, that also follows from the fact that forfeiture of a lease is an extremely disfavored remedy in the District of Columbia. That's the Shapiro case, which itself is a commercial case. So not even the question of taking away somebody's home from them. That case said, there, all the tenant owed was maybe $1,000 in repairs that would take 20 days. The trial court was required to consider remedies other than the extreme and disfavored remedy of forfeiture. I'd also be happy to address the cure discussion that the court was having with the landlord. The landlord starts with the argument that the 2 December payments that Ms. Grayton made, totaling 2 months of rent, could not possibly cure. And he has one argument for that, which is the designation on the money order said October/November 2021. But the trial court addressed this at SA 53 and 55. The trial court said, I have to look at what this tenant did in response to the defective notice to cure that she got. That notice is at page 86 in the supplemental appendix, and it's just wrong in telling her what she has to do. It says, you have not paid anything for October or November. You must pay the entire balance of what you owe and pay timely the next month within 30 days. And that's just inaccurate. And so it can't be that the landlord is allowed to profit and evict Miss Grayton because she responded and wrote on her money orders in response to a notice that was simply incorrect. And no amount of case law from the 1800s can respond to this. Even if the court was to reject that argument, again, the stay DC payment for approximately $2,300 would have certainly more than covered the February 1st payment and would have actually had her prepaying. The court is right that this is not in the record. It appears that the landlord's supplemental appendix 3, it was not one of the exhibits that was ever entered at trial, and we know that because the landlord submitted a precipice of those exhibits on December 4th of 2024. And so no matter how you square it, the landlord can establish that none of those 6 months counted toward the February 1st cure.
Go ahead.
You explain, I'm sure I'm missing something, but why isn't it okay? Judge Ricard treated the October, November payments as going to the January, February rent, I think, is that right? Why isn't it okay to just consider those 2 checks that she designated as October, November for October, November? I'm sure I'm missing something simple.
I think that is permissible.
Okay.
The magistrate Judge Ricard explained that there were multiple ways to calculate it. So he started with designate those 2 checks that we're talking about as paying forward. But then he said, well, you could also start with the stay DC payment, count that starting at February 1st, and then look at those October, November designations and have them count for those months.
Okay.
And that's just why there are 6 months of payments. Any way you shuffle it around, as the court has already acknowledged, that shows there's no harm to the landlord if it's just a question of moving money around. And in order to prevail on the cure, the landlord has to win that none of those payments could count.
Okay. Did you?
I basically had the same question. I just don't understand why we care about October, November. I mean, so what? What if it was put toward October, November? Those were months that also amounts were owed for. I don't understand. I've never understood the import of this argument in the briefs. Like, so put those toward October, November, and the state DC payments are the ones that apply for December, January, February, right? I mean, why are you fighting the memo? What was the error in the landlord's notice to cure that they made that prompted this erroneous October, November notation on the check? Why does any of this matter? I'm just lost in the argument. I've never understood it.
I agree. None of this matters, and she still prevails, even if you count those payments as October and November. So I'd be happy to stop there, but
Why is it kind of good for you not to do that? Why do you think it's kind of advantageous?
yeah, so I think it's important to emphasize what the trial court said, which is the landlord is trying to deprive Miss Grayton of her home and say she didn't cure because of how she designated the checks. And she did that in response to a notice that induced her to make that designation. And so there's a huge power differential between tenants and landlords, and it's landlords shouldn't be able to deprive tenants of the right to cure by inducing them to label payments in a certain way. But I think you're absolutely right. However you move those payments around, Miss Grayton cured, and so the court certainly doesn't need to address that question, and it can allocate those payments to October and November. And
Now, you started your argument by saying you wanted, to deal with the redemption issue and we don't have to even look at anything else. But is that true? Like wouldn't we have to still address Mr. Forster's arguments about cure? Because if he's right about it, and there's like, willfulness or recursion, would that still all be rendered irrelevant by the redemption?
it would be rendered irrelevant by the redemption. So the argument that she did not effectively cure, the landlord is relying on the Borger versus Nelson Lee case for that. And that's just about the question of effective cure. It doesn't have anything to do with whether a tenant was entitled to the equitable remedy of redemption. I'll also note that the Nelson Lee case just notes that effective cure, the possibility of an ineffective cure in dicta, and it suggests a couple of factors that might be relevant. Judge Ricard squarely addressed that argument in this case, though. That's at SA 62. And he said, Nelson Lee asked, quote, whether a cure is simply manipulative, and the landlord can't establish clear error from the trial court's determination that somebody who pays well over 6 months rent within the cure period was simply trying to manipulate the cure. To be clear, though, redemption is entirely separate from whether someone cures. Thank you.
Thank you very much. Mr. Forster, we'll give you the 5 minutes for rebuttal.
I want to start by Judge Beckwith. I believe you were asking me about March. I'll point you to page 55 of Judge Ricard's opinion. He says, I find that there is no showing made by plaintiff that the defendant's conduct by not timely paying rent in March and paying rent late in April, that was a recursion. So his order seems to suggest that he found that there was no timely payment in March or April. So that was the first thing I wanted to point out. I wanted to distinguish Pritch as well. It appears from Appellee's argument that the claim for habitual late payment would no longer exist.
Wait, can you just go back and say what you said? He says, I find that there's no showing made by plaintiff that the defendant's conduct by not timely paying. So you're saying he's assuming the
I'm saying he's saying that there was no timely payment in March, but he's not considering that because there was a cure on February 1st.
Okay, I don't know if I would read that way, but okay, I see your argument.
So he does only addresses March, April. He was talking about March, April, May, and June, and basically saying, there was no timely rent in March and April, but I don't need to get to that because.
But doesn't he somewhere else say, when you add up all the amount that it covers March?
Your Honor, I don't recall that.
Okay.
I could be mistaken.
Okay.
I don't recall seeing that.
Okay.
I'd also like to talk about Pritch. I think that's distinguished from this case. Pritch involved a misunderstanding and extenuating circumstances that did not exist here. And Appellee's argument would completely defeat the claim for habitual late payment. If you could just always cure, you could never bring a claim for habitual late payment because someone could just cure and they couldn't bring it. So that claim would just cease to exist. And that can't possibly be the ruling here based on the precedent. We made the argument in the brief that the equitable argument need to be made in a counterclaim or a motion. It was never done so. It was brought at the eve of trial. The breach was willful. She did not pay in March. She paid late in April. She paid late in May. Those were all willful decisions. And if the court is weighing the equities,
Why? Why would we say that?
why would we say, I'm saying,
Maybe she didn't have the money on March 1st or April 1st or May 1st. What precludes that?
what precludes that is her own admission that money was not an issue. If you look at the judgment at 53, I believe, she's
All right, maybe she had a sick family member and she was tending to other things at that time. Are we as an appellate court are going to make a finding of willfulness? Is that a finding that's been made on the record thus far?
it's there was not a finding of willfulness on the trial court level, no.
Right.
But you can look at the appellee's behavior and the fact that there's nothing in the record excusing those breaches, and that she only paid when she was required to under into the court registry to find her willful behavior. You can look at, we cited WILLIE and versus Kirby and
She was sufficiently in need that a third party had to come in and pay a few $1,000s on her behalf. That does suggest, that just suggests to me that this wasn't likely a willful withholding of available cash from her landlord.
Well, the state DC program was available to tenants during the pandemic. She applied for it, but her own admission is that money was never an issue. So if we take her
I
at her
think in
word,
context, when I read that, I didn't think she was saying what you're saying. I think she was saying that the particular dispute that she was having with the landlord then related to the conditions in the apartment. And was not itself a dispute about money. That's the way I had interpreted that.
I interpreted it slightly
that's
differently.
wrong?
And Judge Ricard made no finding that she didn't have the money to pay. I don't recall seeing that anywhere in his decision or the record that there was any reason she could not pay financially. So I only have 9 seconds left, so thank you.
Very much. Thank you, both sides, for your briefing and your arguments in this case, and the case will be submitted. Second argument on this morning's calendar is number 24 CF 992, Willie Frazier Jr. versus United States. Whenever you're ready.
Good morning, Your Honors, and may it please the court, Victoria Hall-Palerm on behalf of appellant. I'd like to reserve 2 minutes for rebuttal. Reversal is required for 2 independent reasons. First, because the police seized appellant when 3 armed, uniformed officers took up positions around him, obstructing his main path of egress and singling him out for repeated and implicitly accusatory questioning. And second, even if he was not seized until Schemmel saw what he described as an L-shaped bulge, the totality of the circumstances at that moment did not give rise to a reasonable articulable suspicion that he was armed. Turning first to the seizure, appellant was seized by the time officers Schemmel, Moore, and Layelli stood around him, which happens at the latest at 16:37:23 on the body-worn camera. At that moment, a reasonable person in Mr. Frazier's position would not feel free to leave. Several key facts combine.
Before we get to those facts, can you tell me where, do you think we have a trial court finding that the officer has not seen the gun at this point?
I think we do have that finding, and I have sort of two places I'd point the court to. So first, we have at page 7 of the trial court's findings. This is 324 at 7. He is sort of quoting and paraphrasing Officer Schemmel's testimony, and he says, "I continued to speak to Mr. Frazier and the other two officers approached. I observed an L-shaped bulge in WF's groin area and then moved my camera." So I think that is a finding that the officers had approached before he saw the bulge. And then I think
I
it's,
mean, they approach at various times, you know, it's kind of it's conversion. It's not obvious to me that Officer Schemmel even sort of sees, you know, one of them is mostly not in the frame, if I remember right. One of them you can see a little bit more clearly, but it's kind of out of the periphery. Anyway, what's the next one?
the next one is in the trial court's legal analysis at page 10, I believe. He's talking about whether or not he was seized by the time Officer Schemmel saw the bulge. And the trial court basically says the seeing of the bulge and the seizure happened at the same time. And he's saying, this is, I apologize. He says that there's not a show of authority other than the number of officers, which there are quite a few of them, and they're armed. So the trial court's legal analysis is that's not a show of authority sufficient for a seizure as a matter of law, but implicit in that is the factual finding that the officers are present. They are around and standing by the time that's taking place.
They're around and standing by the whole time. Well, I mean, they're in the background for, you know, during the whole interaction. I don't know why that gets you the. I mean, I think the record is not totally clear on this, so I don't mean to belabor it, but I don't know where we have a finding that he hasn't seen the gun by the time of the second of the clip that you're pointing me to, which is sort of a distinct, where it looks like the other two officers seem hip to Officer Schemmel seeming to really focus in on this guy. It's just not clear to me if he's seen the gun by then. The testimony isn't totally clear to me. The findings are not clear to me, and I'm not sure saying that the officers were around tells me anything because they've been around. They've been around for the minute before that too.
So I think that's not I don't entirely agree with that characterization, right? So there's a period of time where it's basically just Officer Schemmel, and you can see, I believe it's Moore who stays in the area, but is sort of walking around and is not in any meaningful sense close by, right? This is sort of between 16:36:30 and 16:37. Moore is at various points in the frame, but at quite a distance. And then Officer Layeli is one of the officers who was involved in chasing the man who fled. And he is nowhere until around 20 seconds, he comes walking quite quickly. And so I think when the trial court says there was no show of authority beyond the number of officers, which there was a few of them, they were all in uniform and armed, I think that is talking about a point where there were a number of them in the relevant area around WF. I wasn't sure if there was a question there. But I mean, I agree, Judge, that the findings are not exactly a model of clarity, but I definitely don't think that there is anything in the findings that would support that Schemmel saw the bulge before then. And in fact, at one point, the trial court even says that he found there was reasonable suspicion when Schemmel said he saw the bulge, which would almost be a finding that he saw the bulge as he said he saw the bulge. And Schemmel's testimony on this point sort of says various things at various times. But I think that sort of suspecting that he saw it at some earlier time would not be supported by the record.
Suppose it is true, as you say, that, or as you argue, that the other two officers had gotten into position, and that you could even view that as restraining Frazier's freedom of movement. But Officer Schemmel is right there and has been right there beforehand. What is the causal relationship, or does there have to be a causal relationship between the circumstances that you say amount to a seizure and the discovery of, and Schemmel's discovery of the gun?
So I think that under this court's case law, if this court agrees that the three officers were surrounding WF and impeding his ability to leave or sending the message that he was not free to leave before Schemmel saw the bulge, then
Bearing in mind that he wasn't trying to leave.
bearing in mind that he had submitted to the show of authority, right? If this court finds that there was a show of authority and his not standing up to go is only an indication that he was submitting to that authority, then the fact that Schemmel a few seconds later sees the bulge, that is the fruit of the seizure, because you know, the legal conclusion is that Mr. Frazier didn't get up to leave because he did not feel free to leave. And so his Schemmel's
Just focusing now on the relevance of the other two officers. I mean, the way I look at this is it's sort of different from the cases we've had where somebody is walking down the street and the police come and they stop the person. Here, there's nothing like that. Frazier is sitting there. The officer comes up to him. Police are allowed to come up to people and talk to them. That doesn't count as a seizure. And he stays there. He doesn't object and say, I've got someplace to go. He's continuing to look at his phone and going about his business. And it's not clear to me that even if, it's a debatable point, even if the two officers who see that Schemmel is interested in this guy and they come and position themselves a distance away, whether that has any real legal significance.
So I think it does. And so, this court said in Golden and the Supreme Court said in Brenlin, if you're sitting down, right, you can continue to submit to authority by not getting up to run away. And so I don't think the fact that, I would agree with a premise of the court's question, which is there are earlier moments in the interaction where other people walked away and Mr. Frazier didn't walk away. But I don't think that that means that having chosen to sit down and stay in the area, there is no sort of future point at which the circumstances can sufficiently change such that he is no longer free, or that he would no longer reasonably feel free to leave, right? So he sits down, Officer Schemmel stays in the area directly in front of him. He testifies he was focusing on him a little more, that he stayed in the area.
Schemmel is right in front of him.
Schemmel's right in front of him for about a minute, right? Like he's pacing back and forth, he turns back, he comes back, he looks at him, he's talking to him, he's asking if he's staying out of trouble, he's talking about getting on TikToks. So he's been staying with him for a minute. So that in and of itself is sending one message that Schemmel is sort of not going to let this situation go. And then simultaneously, as Schemmel is sort of escalating the nature of his questions, going from, hey, are you doing okay, to, hey, are you staying out of trouble? Then at that same sort of moment, two other officers are coming and really focusing in on this interaction.
Well, maybe we should talk about what those officers are actually doing. When I watch the body-worn camera footage, and it's only Officer Schemmel, so we only have one perspective. I got that. But the other two officers, I interpret it as they see Schemmel is interested in this guy. So they move a few steps, they position themselves, but they're not very close. It's not like they're all towering over Frazier. They are standing at some remove, but they're alert and they're, ready in case something happens. I don't know if that should be viewed as counting in this case as contributing to the seizure. Is there any indication that from the video that Frazier sort of noticed them and was wary or upset or anything like that? I mean, until Schemmel says, I'm going to pat you down, everything's going along just, hunky-dory. There's no real reaction by Frazier to what's going on.
Well, so first, I don't know whether Frazier's subjective reactions are necessarily the best indicator
Just
of.
looking for everything.
Right. So looking at everything, first, I would slightly dispute the characterization. The other two officers, Moore and Leali, yes, they stand a few feet away, but they are quite close by. I find it hard to believe that someone sitting in Mr. Frazier's position would not be able to see the rapid approach of two armed uniformed officers from.
Rapid, I don't think is fair, but.
Happens over the course of sort of
But
2
they-
seconds. Okay, the regular paced approach of two officers. And then, there is the fact that Officer Schemmel is very close, right? Officer Schemmel is basically within an arm's length. And it's not, returning to Officers Moore and Leali, it's not just that they're walking up. It's that they're walking up from the only area that Mr. Frazier would have had to meaningfully leave and terminate the encounter, right? Everyone who walked away earlier walked away through the parking lot. Mr. Frazier's sitting on a bench. Behind him, there's a sort of hill and a retaining wall. To his right is a concrete building. There's no testimony that Mr. Frazier lives there or would be able to access the building. There's a laundromat, which is a dead end. So the only way he would have to leave, which a reasonable person who had been questioned by an officer for about a minute, very, very close, might reasonably be supposed to be keeping an eye on his exits. Two officers come from exactly that exit and plant their feet and are looking right at him. I mean, I don't think.
Is it significant that it can be understood that Frazier saw these other people leaving the scene and could well have thought, well, if they can leave, I can leave?
So that is a relevant fact. And again, that goes to our sort of concession that at earlier points in the interaction, we have not claimed that Mr. Frazier was seized, right? So when Officer Schemmel and Moore first come up to the group and there's a large group of men and they're coming up to people and asking how they're doing, I think it would be a really, really tough argument to say that he would not have felt free to leave in that moment. And some people walked away. But the facts of how the officers were treating Mr. Frazier is meaningfully different, right? So Officer Schemmel stays with Mr. Frazier for sort of an entire minute. He testifies that after going into the laundromat and coming back out, he walked to the group where Mr. Frazier was standing, and from that point on, basically didn't let him out of his sight. And so that he's treating Mr. Frazier differently.
Do you think that the cases involving, for example, people sitting on buses or trains or whatever, and the police come, do those cases give us any insight into how to treat this?
Well, I think that those cases are meaningfully different, right? So in a bus case, if you're going down the line, just talking to one person after the other, there's no real sort of singling out in the same way. And again, I think those cases are better viewed as analogous to the early stages of this interaction, where Schemmel goes up to the man who lifts his waistband and asks, "Are you good?" And the man lifts his waistband, and then Schemmel walks away. He follows the man into the laundromat, comes out, the man walks away. He's sort of expressing interest in a lot of different people. But I think once a minute has passed and it's no longer just Schemmel, it's Schemmel and two other officers, and Schemmel is asking questions that he's already received a sort of an answer to, right? He says, "Are you doing okay?" Mr. Frazier says, "Yeah, I'm doing good." Schemmel stays with him, comes back, says, "Hey, are you good?" And Mr. Frazier says, "Yes, I'm doing fine." Then Schemmel says, "Are you staying out of trouble?" Right? This is no longer just he's asking questions of a bunch of people. He has manifested an intent to talk to Mr. Frazier, and that he sort of implicitly suspects him of being engaged in some kind of wrongdoing. And we get that from.
Would you be arguing that there was a seizure on those facts if we didn't have those two officers who see Schemmel's interested in him and move in?
I might be arguing it. I think it would be a much, much harder case. I mean, I think the presence of the other two officers.
That's sort of my reaction to it. That's why I wanted to ask you, what's the real significance of, that's why I asked you before, what's the real significance of those other two officers?
I think their presence, and specifically their presence blocking off the main path of egress, is very significant to the analysis. So I think the combination of all of those facts would give a reasonable person in Mr. Frazier's position the distinct impression that he was not free to terminate the interaction, not free to tell the officers that he was done with this conversation and wanted to walk away. And so at that point, I think there was no reasonable suspicion, even if, to get back to sort of where we started, Judge Steele, even if Officer Schemmel had seen the bulge, I think that there was no reasonable articulable suspicion based on a sort of cursory description of an L-shaped bulge, that the body-worn camera pointed directly at the bulge.
What do you do with the fact that Judge Ryan, right? Listens to the officer's testimony, it says, it states his view, which seems reasonable, actually, that things we see on body worn camera aren't going to be exactly like what someone sees with the naked eye when they're there, and says, "I believe what he said."
So I think if you look at what the trial court actually found, right, I don't take Judge Ryan to have made an independent finding based on his review of the evidence that there was a visible L-shaped bulge, right? He says, Schemmel says he sees, this is at page 11 of the findings. Schemmel says he sees the outline. Schemmel testified, I thought credibly. He was careful in what he said and could not say. He was, I thought, very careful. I'm sure one reading that if you look at the body worn camera enough, you're careful about what you say. Perhaps the case, I don't know. But he testified in a way that was consistent with the body worn camera, and I thought credibly. I conclude that there was reasonable suspicion when Schemmel said he saw the bulge that looked like a gun to him. But just the page before, Judge Ryan says, he, as an independent fact finder, says, it is not obvious from looking at the body worn camera that there's a gun there to me. I mean, I think it is relevant that the trial court did not make its own finding of the existence as a sort of objective matter of an L-shaped bulge.
Yeah, I don't follow. My reaction to that is, so like me, I cannot see an L-shaped bulge in the video. I've, tried going frame by frame. I just don't see it. But what I hear Judge Ryan saying is, I don't know if I can see it either. But I believe the officer when he says he could see it, whether or not it's depicted on this video, different, maybe it's not high quality enough, maybe it's just something, you could see better in person. I believe the officer that he sees it. And so at that point, he's got RAS. I mean, isn't that what Judge Ryan's saying?
I think that is what he's saying, and
We owe that just as much deference as a quote unquote independent review of the evidence finding too, right?
so but it's not a matter of deference. It's a matter of whether that suffices as a matter of law, right? And so I think Singleton's a helpful comparator here. In Singleton, again, the trial court, just like here, says, I credit the officer saw a bulge, and Singleton's obviously a pre-body worn camera case. The officer says, I saw a bulge that was consistent with the firearm. The trial court says, I credit that. I credit that the officer saw a bulge that looked like a
So
firearm.
the big difference between a bulge in a pocket, which is what Singleton was, and where we said, well, that could be anything, and an L shape in a waistband from a guy who has previously been arrested with a gun is also part of the suppression testimony. They seem like apples and oranges to me. I mean, a bulge could be a wallet. It could be any number of things. I can't think. I mean, I'm sure you're clever enough. You could come up with something. I can't think of another L-shaped thing. Maybe somebody's keeping a banana down their waistband, but it seems unlikely. It seems like that's probably a gun if in fact you can see an L-shaped bulge like that.
So I think that this is why the sort of fact that Officer Schemmel repeatedly just said L-shaped bulge in the groin area, L-shaped bulge in the groin area is relevant, because you can think of, without testimony, for example, like I think Williams, this court's recent decision is helpful there. He said it was a metallic object. It was thinner. It was more narrow than a cell phone. I could see the slide and the receiver, right? Those are concrete objective facts. L-shaped bulge, without knowing whether it looked like one unbroken object, whether it was hard, whether it was soft. It could be the folds in fabric. It could be a wallet and a cell phone. Mr. Frazier had a kangaroo pouch. There could be something in that pouch and then something in his pocket. I mean, we just don't know. And particularly where the body worn camera, which I think it's striking here that sort of Schemmel did not disavow the body worn camera, right? This is not a case where Schemmel came in and said, that's not what it looked like to me. My angle was so much better. I don't know how it didn't capture. He looked at it and he said, yeah, you can't really see a bulge there. The trial court didn't see a bulge. I don't see a bulge. I don't take the government's brief to be saying that the bulge is objectively
Do you think
visible.
that the fact that when he reached in, lo and behold, there was a gun there, tends to corroborate the fact that he saw what he says he saw? Because if he didn't see what he said he saw and just was reaching into this random person into his groin area, we'll get to the fact that it's in the groin in a moment. It's just a remarkable coincidence, isn't it? That, oh, lo and behold, there's a gun there. I should reach into people's groins more often. He didn't, he does it here because, I mean, the inference is he did it here because he actually saw something, and the fact that he actually saw it is corroborated by the fact that it was indeed there.
I mean, I think we have decades of case law from this court and the Supreme Court that a search can't be justified by what it turns
This is
up.
not justifying the search as a result of what it's found. It's just saying that what it's found corroborates the truth of what he was saying he saw.
But that'll be true in every suppression case, right? We never see the cases where the officer has a hunch.
The gun could have been in his back pocket, right? Then it wouldn't corroborate where the officer said he saw the gun. It could have been drugs instead, and then it wouldn't corroborate it. I mean, guns can be held in any number of places. It happens to be right where he gestures it is. Although I will say he does the handle. He handles in the wrong. The handle's in the wrong direction. I think
So
when
to
he
the
does it.
extent that, so I think it's our position that it's sort of illegally erroneous to look at where the gun was actually found as reverse engineering proof that the officer actually could see what he saw. I think there's a real through line in this court's cases of fear that officers are acting on a hunch, might be a good hunch, but it's a hunch nonetheless. And then they find what they had a hunch for, and that's still not good enough. Just because they found it doesn't absolve the search.
No,
To the extent,
but here he's saying, I saw this, outline, a bulge of a gun, and it was in his groin, which, by the way, people don't carry things in their groin normally, so that's suggestive too. But regardless of what it was, why would he be hiding? Why would it be there if he wasn't hiding something? Corroborative. But I don't think it's justifying the search by what it found. It just indicates that when we are deciding whether to credit what the officer said he saw, the fact that it in fact was there supports that.
I guess I'll just have to, I disagree. I think that this court's cases sort of repeatedly say that the fact that you found something does not mean that you were right to conduct the search unless there are other objective things that you can point to ex ante. And then sort of to get back to something that Judge Deal just said, to the extent that you want to look at where the gun was, Schemmel was wrong, right? Schemmel repeatedly says, I pointed like this, up and down and to Mr. Frazier's left of his body, the right as your Officer Schemmel. That's not where the gun was, right? So his hunch was wrong. I mean,
I'll tell you something funny. When I was going through the video, and I was going through this frame by frame, which, by the way, in any event, at one point, when I had to have turned this upside down on the screen to see it, I actually saw the outline, what looked to me like the outline of a gun. And unfortunately, it's for a split second, and I'm not relying on that in the slightest, because I don't think it's what Schemmel saw, frankly. But you know, it's in the eye of the beholder, I suppose.
and I think this is why it's so important that there be objective, sort of concrete evidence for judicial evaluation, right? Like Mr. Frazier's he's wearing a jacket, he's wearing a sweatshirt. The sweatshirt has a big pouch. There could be any number of bulges at any point based on how his clothing is bunching, how the things in his pockets are lying.
It's true, all that's true.
And
It's just a question of reasonable articulable suspicion.
the question of reasonable articulable suspicion. And I think that where the officer has repeatedly just said L-shaped bulge in the groin area, and when tried to sort of press for specifics, gives either specifics that turn out to be objectively wrong or gives specifics that kind of don't make sense. He's asked, is it the abdomen? He says, yes, the abdomen, the waistline area. Then at one point he says it's protruding from his leg, right? And if you look at the video, those are all different places, right? There's the waistline, there's the sort of seam of his pants, there's his leg. Those are all different places. And we sort of don't know where the objective bulge was. I think there's a real fear, right, of officers just saying L-shaped bulge in the groin area as a talismanic litany to get around from Singleton and say, I saw a bulge that looked like a gun, using new, seemingly objective language that still doesn't really have concrete teeth. And particularly with
But
that
the
statement.
judge I mean, it's within the judge's right to credit him when he says, I saw this L-shaped outline. Judge says, I credit that. I'm the fact finder. I don't think-
Absolutely.
It's hard to overturn that. And an L-shaped bulge in the groin is suspicious.
So I have two different answers to the two parts of that question. I think we have not challenged the trial court's credibility determination that Schemmel could see an L-shaped
I
bulge.
appreciate that.
It's just that the body worn camera gives the court evidence of what the actual facts on the ground were, separate and apart from Schemmel's perceptions. And we just don't see the bulge. And so when you have that, I think it's our position that that's just not reasonable suspicion, because this court's cases have said.
So it sounds like you're asking for a bright line rule, basically. If no one can look at the body worn camera and see the thing that the officer says he saw, that the judge crediting the officer is not enough.
I mean, not necessarily. I think all of this is a fact-intensive inquiry. And if, for example, there is a case where the body-worn camera is sort of vague and you can see some bulge, but you're not sure, or where the officer has testified that there's some reason that the body-worn camera is sort of imperfect, right? So if it's dark or if he's angled the wrong way. But here, right, we have Schemmel repeatedly saying, I took pains to ensure that the body-worn camera would see what I see. And so we can see the body-worn camera and it shows nothing. And so I think that on these facts, that's just not reasonable suspicion. And I also don't think that's a tremendous leap from this court's prior cases in sort of Singleton and Williams, where even in Williams, where there's more concrete testimony and there is, I think the court says that the body worn camera sort of neither is at best unclear on this point. I think this body worn camera is more than unclear. I think it's sort of clear that nothing's visible. The court still said, we're wary of resting just on testimony about a bulge, but luckily there's more than a bulge. And here, I think the things that the government has pointed to, and I know I'm out of time, but I think that the other facts that the government has pointed to are quite weak tea under this court's prior case law. And so I think that they all combine to make the bulge sufficiently suspicious for reasonable suspicion.
I guess one thing about it is the officer just keeps saying, right there, you see right there. And you want to think like, would he really be saying that much if he weren't actually seeing it? And I guess the opposite conclusion is that he's just being really manipulative, but you have you have that's where the trial court's kind of credibility finding comes in.
Right. I mean, I agree that this is not a case where the officer doesn't say anything on the scene or in the Gersh scene and then comes to the suppression hearing and says, I saw a bulge, when he's never said that before. He's been consistent from the start that he believed he could see something. That is one fact, but I don't think that that necessarily gets you over the hump of whether it is reasonable for him to believe that whatever it was that he was seeing was a firearm, which is sort of the ultimate question.
Okay, thank you, and we'll give you some time for rebuttal.
Yeah.
Good morning. May it please the court. Mary Fleming on behalf of the United States. The totality of the circumstances shows that the trial court's conclusion that the officers had reasonable suspicion to stop Mr. Frazier was correct. That reasonable suspicion developed before the time that Mr. Frazier claims the seizure occurred, which is at 16:37 and 23 seconds on the body-worn camera. And that is when the third officer walks up and is standing near Mr. Frazier. By that time, Officer Schimmel had already seen the L-shaped bulge. So even if Mr. Frazier is correct about when the seizure occurred, there was reasonable suspicion. Although the trial court did not identify the precise moment when Officer Schimmel saw the L-shaped bulge, we know it was before 23 seconds. The court said, I observed an L-shaped bulge in Mr. Frazier's groin area, and then he moved his camera, talking about Officer Schimmel's testimony. And the court does preface that by saying, I continued to speak to Mr. Frazier and the two other officers approached, but the officers were approaching during that time. So I don't think that's a finding that the officers were standing at close to Mr. Frazier and then Officer Schimmel sees the bulge. And the trial court's findings are consistent with.
I don't quite follow. So I'm watching now. And actually, I had thought this point maybe would have been one of the stronger ones against your position, which is the camera is on the two other officers, Moore, and I forget the third officer's name, at 23, the 23rd second, as they approach. And that's when his camera shifts over, and he seems to say, I sort of position my camera upon noticing the bulge, suggesting that these officers are coming in before he notices the bulge. So what am I missing?
So I think if you watch the body-worn camera, and the frame by frame is really helpful, at 22 seconds, he is starting to move his camera. I mean, it's a few frames before the clock hits 23 seconds. And by 23 seconds, his camera is moving. And I think that Officer Moore's body-worn camera, which is Defense Exhibit 25, that I believe was entered into the record on appeal, you can see at 23 seconds, Officer Schimmel is moving. I think his one foot is in the air. And even if reasonable suspicion and the seizure occurred at exactly 23 seconds, that's still fine. There was reasonable suspicion when the seizure occurred. So based on those facts, we think that the court can find from the record evidence that Officer Schimmel had spotted the bulge before 23 seconds. The court summarized the testimony that way. Officer Schimmel testified that way, and then the body-worn camera is consistent with Officer Schimmel's testimony.
It seems to me that if we really wanted to cut it this finely, we would want a more express finding from the trial court. I mean, that's my reaction to both of your arguments, which is if this is what is load-bearing in the case, and I'm not saying that I think it is, but if this is what is load-bearing in the case, then you got to tell the trial court, give me the second. Or give a preliminary ruling that if it's the second before this, then it's if he sees the second before seeing it, then this needs to be reversed. Otherwise, you can affirm. But I don't get how we're gonna say the trial court has found he sees the gun before those two officers move in. I mean, it's all bang, 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 and no express finding on it.
Two responses to that. One, we have an alternative argument that the seizure did not occur until later. So if the court disagrees with that and thinks that on this record, it needs a factual finding from the trial court, then we would ask for a remand for that. But we don't think, our position is that the seizure doesn't occur until later after Officer Schimmel clearly has seen the bulge because he's verbalized it. And so the seizure, so clearly by then he has reasonable suspicion. And I can address that.
The government argue at the hearing that that Officer Schemmer saw the bulge before the officers came in? I don't think that was ever suggested.
It wasn't focused on in the same way it is here. Our argument below was that the seizure occurred later. So that's what we were focused on. And I think in our
I'm sorry, I misheard something. Your argument below was that the seizure,
occurred much later, or not much later, but 10 seconds later or so. This focus on exactly when he saw the bulge versus moving the camera and all, that wasn't a focus. And I think that's maybe why we don't have clear factual findings on it.
can I ask you to speak to now the argument that the seizure occurred when the other two officers moved in a bit to position themselves?
Sure. So I think we have to view that in the totality of the circumstances. The officers approached a group that outnumbered the officers. People were coming and going. Even when Officer Schemmel was questioning people, not even explicitly, but just, hey, how are you doing? People left after that, which I think to a reasonable observer would suggest that even when someone has the officer's attention, they're free to walk away. As to the specific surrounding of Mr. Frazier, the exit pass, it was a wide open area. The exit paths were not blocked. And we think Golden is helpful on this issue where the cars that converged on the defendant in that case, this court, we think as a holding said that at that point there was not a seizure. So the officers kept walking up. It's not clear really why they walked up. Maybe it's because they saw Officer Schemmel talking to Frazier, but we don't know in the record. And we think there was enough space. It's also
The question is how it would have been perceived by Frazier.
right, but in the totality of the circumstances, given that other people had walked away, he wasn't the focus of the inquiry. It's not like they came up and were just talking to him immediately. Do you have a gun? We don't think the questions that were asked, how are you doing? Good.
But it isn't, are you staying out of trouble? Is that what they asked? Are you staying out of trouble? How is that different from, do you have a gun, especially given their history?
In the context of the conversation, I view that more as a casual comment. It says, how you doing? Good. Yeah, staying out of trouble. Yeah, I'm going to school. Even if that is an accusatory question, which we disagree with, that's the first arguably implicitly accusatory question. And I think as the trial court noted in discussing this interaction, gun recovery units or crime suppression units previously have come up on people, immediately asked, do you have a gun? And this court has been critical of that approach. I think TW is a good example where the officers converged on someone immediately asking, who you have a gun? Do you have a gun? And the court said there, the officers didn't greet him and they didn't, ask how he was doing. And so here the officers are taking a different approach.
I don't think we said that. I don't think we asked for a greeting.
But the officer, this court did say,
Do you have a gun? Do you have a gun? Do you have a gun? Suggested that somebody's not free to leave. That's definitely true.
I don't know if I'll be able to pull it up right now, but I think there was a comment in that, maybe not about a greeting,
Sure.
but saying that the officers,
Fair enough.
I
I
think
did not mean to derail you. I just didn't think the lack of a greeting was of relevance, but yeah, sure, that there's not some sort of casual conversation but instead it's straight accusatory. I agree. So
When you have people lifting their shirts up, doesn't everyone there know they're looking for guns?
I think everyone there knows they're police officers and sure, they're there to investigate what's going on. But the case law is clear. Officers are allowed to approach. They're allowed to ask questions. They're even allowed to ask accusatory questions. The question is whether a reasonable person would feel free to leave. And we think given the totality of the circumstances, Mr. Frazier would have felt free to leave.
When you said that it was a real open space, can you I'm not sure I did look at the videos, but to his right,
He's sitting on the bench.
going toward the laundry room, what's the situation over there? Can you leave that way?
So I think you can. There is an archway that you can see in the body worn camera, has daylight on the other side. There's not evidence in the record as to what is on the other side. If you look at Google Maps, it's a courtyard that leads to a street. So, but we acknowledge that's not on the record, but you can see an archway that has daylight behind it. There's also a laundry room next to it that is a dead end. But he's in a wide area. He's not in an alley. There is
Other people didn't leave. Did other people leave through that archway?
I don't remember that from the body worn camera. I think Mr. Frazier's counsel's correct that everyone left through the parking lot, but it was a wide enough open area. We don't think it was like the cases where officers are converging on someone, particularly a lot of the cases happen in an alley or someone's back is up against a building. That's not what this case is. I would like to touch on the L-shaped bulge. We think this case is very different from Singleton or Golden. The testimony was that there was a bulge, it was in the shape of an L. The body worn camera shows the approximate size of the bulge. He's pointing at it. This is not a bulge that could be anything like in Golden, or that a bulge that is simply consistent with a firearm like in Singleton.
Can you see it in the camera?
I could not. I know Judge Glickman suggested maybe he could. I think it's hard. We certainly didn't argue. You can see it in the brief. I think the court said they couldn't see it. Officer Schimmel said, yeah, I don't think you can see it. So, but I think it's common sense that sometimes you take a picture or a video and you can't see what you see in real life, especially if we're relying on something underneath clothing. And I think
So it
too,
is a little surprising that the officer is actually trying to make it visible. He's trying to make it visible.
right. And you know, I think too, I mean, maybe the fact that it was broad daylight makes it harder because there weren't shadows, like there would be maybe in a different circumstance, but the court credited his testimony. We think that ends the inquiry. It's not like anyone is contending that he was lying about seeing the L-shaped bulge. So if he saw it, we think that's enough. And then there's other factors too that we think support his view, the officer's suspicion that the bulge was in fact a firearm, but we think that the bulge is strong evidence that gives rise to reasonable suspicion.
I think you were gonna say distinguish Singleton. What's your reaction to Singleton?
Well, in Singleton, all the officer said, I think, was that the bulge was consistent with a gun and didn't describe the size or shape. And here we have a description of the shape and from the body worn camera, the approximate size. So I think on that basis, Singleton's factually distinguishable.
Are you finished on that subject? Could I ask you to go back to the question of seizure? And if and when it occurred? Can you think, what is, I should have asked this of Miss Palermo, and she'll get a chance to answer it too when she gets back up. What is the closest case you can think of to factually in the Fourth Amendment area to one like this, where you have these one officer standing over or still talking to at close range the suspect, and two other officers are sort of in the vicinity. They're not towering over him, but they're in the vicinity. I'm wondering if there is a close case that you would rely on that says that this does not amount to a seizure.
If I could point to two cases. One is Kelly, where
Say it again, please.
Kelly,
Kelly.
where there was an officer it was two officers there, but there was one officer talking to the defendant. Another officer was about 4 feet away. This was in Union Station. And this court said that positioning would have the defendant would have felt free to leave. And I will say in that case, there was I think the exit was to Kelly's left. So the court said he could have walked out the doors to the left. But there's also Brown, where the officers approached a group similar to this case. And one officer was a couple feet away from Brown. Another officer was kind of in the area talking to other people. It's a little unclear exactly how far, but I think that's helpful too, to suggest that that wasn't a seizure.
Can I ask, is your response to Ms. Hall-Palerm's argument that, reasonable suspicion, that's hard to say. We ought to have something, when you have a situation like this where pretty much everyone's looking at this video and saying, I don't see that. So there ought to be something besides what it boils down to a trial judge's unwillingness to, or to say an officer lied, or, it's hard to have a basis for saying the officer lied. We should have something more objective if in a situation where no one is actually seeing it on the camera.
Our response is that there's many cases where the testimony of a single officer is enough, and it's the court's province to make credibility findings viewing the officer's testimony, and the court credited it. The court didn't have to do that, that the court was careful in assessing the testimony. So that would be our response to that. If there are no further questions, we'd ask that this court affirm the trial court's judgment. Thank you.
Just for my own sake.
The question come back. Is the mere suspicion, even if it's reasonable, that someone has a gun, a handgun in their possession, is that enough to give reasonable articulable suspicion that a crime is being committed, given all the laws and developments there have been that allow gun ownership in the District of Columbia?
Sure. I know that issue is percolating before this court. I think here, no one's argued that, of course, and I think there's an easy answer why Mr. Frazier was 18, so he wasn't able to register for a firearm. So I know that issue has been percolating, but I don't think that has to be addressed here, including because it's never been raised.
But
Right.
I was just gonna say, you're right, that we did say in TW, that they didn't greet them, among other things, so
I'm
unfair
sorry.
interruption on my part. I shouldn't have interrupted you on that.
I'm sorry. Thank you.
Ms. Hall-Palerm, we will give you 3 minutes.
Thank you. So I think I just have 2 points. First, looking at Williams and Williams relying on Singleton, this court has always said that it's not just a bulge alone, right? Even when there is concrete testimony about it, this court likes to see other evidence that would give an officer a concrete reason to believe that the bulge, whether L-shaped or otherwise, is a firearm. And so
does hiding it in the groin count as other evidence?
I mean, I don't think so, because, well, the bulge in Williams was in a pocket, but I don't think so, particularly where, as here, there's a sweatshirt, right? And so when you say in the groin, it could be in the pocket of the sweatshirt.
I thought it was in his pants.
Well, this is part of why Schimmel's unclear testimony is so important, right? It's unclear whether he means in his pants when he says waistline or abdomen or leg. It's just sort of unclear. And the other facts that the government has pointed to in its briefing, it didn't.
Well, I thought it's clear that am I mistaken about this? I thought it's clear where he finds the gun.
It is clear where he finds the gun.
So, oh, you don't like my.
Right, we're back to where
my
we
retroactive.
started on that question. And then, on the other evidence, which the government sort of didn't really talk about today, I would like to address the reference that Judge Deal, you made in your questioning with your back and forth with me earlier about his prior criminal history. I mean, I think that that's really not developed in the record. Schimmel does not say anything on direct, right? On direct, he says, I talked to Mr. Frazier a little more because I knew him. Doesn't say anything about the criminal history. And then on redirect, he said, I had prior knowledge of him being arrested with a firearm in my personal experience. Very unclear what that means, like what the nature of his personal experience is, the basis of his knowledge. Unclear how long ago, unclear the disposition of the arrest or the facts underlying it, right? Like Mr. Frazier could have been in a car with 3 other people and everyone was arrested because there was a gun in the car. We simply don't know. And so I think the cases, which all come not from this court, but the other cases that have permitted prior criminal history to inform reasonable suspicion have relied on a much closer nexus and much more developed testimony on actually what the nature of the prior offense.
I agree it's not super well developed, but that he was arrested with a gun, I think is the phrase in the transcript that he testifies to. I think he says, my memory is that he was saying he had prior knowledge prior to this incident. And, we happen to know that Mr. Frazier is only 18 years old, could not lawfully have a gun. So you can, there was an opportunity to develop this more if anybody wanted to. You could ask to reopen. Somebody could have fleshed this out, but the most natural implication of all of the facts are, I know that this person has previously been arrested for unlawful possession of a gun. And that plus, here's an L shape that I'm seeing, sure seems like reasonable articulable suspicion.
Well, so I think when you say anyone could have developed this, right, it's the government's burden to show that the intrusion.
I know,
was
I'm
justified.
suggesting that they put in enough that the reasonable inference, I agree, they probably should have done more, but the most natural reading of this is this individual has previously been arrested with an unlawful firearm.
I mean, I agree. So this is at page 33. He says, prior to this, I had knowledge of the defendant being arrested with a firearm. Again, if you look at sort of these cases from the First Circuit that we cite, Meadows, Peters, you really need to know how long ago, right? Was this 4 or 5 years ago? How reasonable is the inference that that informs his behavior today? What was the nature of the facts underlying how he was found with the gun? Was it on his person? Was it in a car? Was it in a shared room? I mean, we just don't know. And when the burden is on the government to elicit the facts that would, the concrete underlying facts that would contribute to an officer's reasonable suspicion. And I just think that they failed to do that here with that sort of cursory testimony. And then sort of, sorry, one last point, I know I'm out of time, on the body worn camera and sort of how to consider the body worn camera in relation to Officer Schimmel's testimony. This court has said repeatedly, this is in Mayo, this is in Jackson, that the court needs to look both at the evidence that supports reasonable articulable suspicion and the evidence that detracts from reasonable articulable suspicion. And so here, where Officer Schimmel says L-shaped bulge in the groin area and nothing more, and the body worn camera, which is in the record, which the government introduced as evidence of the reasonableness of the suspicion, shows no bulge, right? No one standing in this courtroom has seen a bulge other than maybe for a split second, Judge Goodman. That has to.
Could have been a hallucination,
No, we don't know. And when we don't know, that has to factor into the reasonable suspicion analysis.
Could I, before you sit down, would you like to answer the question that I
I'd
also
love to answer that question.
asked other counsel?
So
In terms of this question of the police,
Converging.
what's the closest case that you can think of that supports your position?
So I think Judge Deal might not agree. I think the closest case is Urban. I think.
I thought you might say that. No, I think it's reasonable, but there is a total encircling there, and I understand it. Imagine your reaction is,
Which case?
Irvin.
Irvin. Oh,
Yeah, so in Irvin, you have 5 officers completely encircling, but in Irvin, Mr. Irvin was standing in an open field. And so in order to effectuate the sort of hemming in, you really needed to surround him on all sides. Otherwise, he could have just walked in any direction. Given the sort of pre-existing architecture of where Mr. Frazier was and where the buildings were, I think the presence of 3 officers very close by between him and the only exit that anyone had availed themselves of is sort of functionally equivalent to Irvin. I think Kelly, which is a 1989 case where it's plainclothes officers, 2 of them in an open space not surrounding him, is a pretty different story. So we'd ask the court reverse.
Very much. Thanks to both sides again for your briefing and your arguments today, and the case will be submitted. The third and final case being argued this morning is number 25 CV 571, HAMZA FAROOQUI versus SILKWAVE Holdings Limited et al. Whenever you're ready, counsel, or whenever your opponents are ready.
Good morning, Your Honors, and may it please the court. Brandon Trice for the plaintiff appellant HAMZA FAROOQUI. I would like to reserve 3 minutes for rebuttal. For more than half a decade, the plaintiff worked on behalf of the defendants to help them acquire satellite assets and build a satellite enterprise that the defendants themselves publicly valued at more than $4 billion. They knew that Mr. FAROOQUI was not working for free, and that they knew that he expected compensation from them. Indeed, the defendants repeatedly requested services from Mr. FAROOQUI over the years, and the parties engaged in extensive negotiations about the form his compensation would take. Those negotiations culminated in an oral contract in September 2018, pursuant to which Mr. FAROOQUI was awarded equity for his prior work and a success fee for fundraising work for the businesses going forward. Mr. Farooqui continued to work for the defendants for several months, receiving assurances that he would be paid. Indeed, defendant Charles Wong's last email to Mr. Farooqui said, quote, "My promises are golden." They were not. In March 2019, the defendants abruptly cut off communications, having never paid Mr. Farooqui a penny. He sued less than a year later in October 2019, diligently built his case through discovery for several years. In December 2022, Judge Todd Edelman, to whom the case was previously signed, rejected the defendant's motions for summary judgment in a thorough 31-page decision. That should have enabled our client to go to trial. But 2 years later, in January of 2025, Judge Alfred Irving, to whom the case had been reassigned, made the unusual move of sui sponte ordering renewed summary judgment on two discrete issues. One was whether defendant Qingji Zhao could be held personally liable, and the other was whether the statute of limitations applied, which is something that nobody had ever argued in the case. What followed was even more unusual. Judge Irving proceeded to issue a decision not based upon the statute of limitations that he had raised, but he instead held that all of Mr. Farooqi's claims that were before him failed as a matter of law because he had reviewed the same exact evidence as Judge Edelman, and he had concluded that actually no reasonable juror could find in our favor. Indeed, Judge Irving acknowledged that the facts did not, quote, "differ significantly from those before Judge Edelman," and he never identified any change in law. Yet he only mentioned Judge Edelman's name twice in the procedural history, and he never dealt with his legal analysis at all. Judge Irving's decision was wrong. It's a prime example of why the law of the case exists. As this court said in PPP, except in a truly unique situation, no benefit flows from having one trial judge entertain what is essentially a repetitious motion and take action, which has as its purpose the overruling of prior action by another judge. Or as the DC Circuit sitting in Bonk said in the LaShawn A case, inconsistency is the antithesis of the rule of law.
So you think that if we think that Judge Irving was correct, we nonetheless should overrule him?
So Judge, our position is
That
that,
seems odd.
well, our position, Judge, is that this court has in the past repeatedly held that the law of the case, if a trial judge departs from the law of the case, that is an abuse of discretion. That is something that this court, in our view, should encourage trial courts to deal with in the ordinary course. We don't dispute, obviously, that this court has the power to reach the merits, and we feel very confident that we're correct and Judge Edelman was correct, so we're happy for the court to do that. But I do think that this is a good case. It's very stark circumstances here where there was summary judgment renewed sui sponte years later on issues that weren't even really ultimately.
What if it had been the same judge?
If it had been the same judge,
I've reconsidered and now I changed my mind.
I think the law of the case would bind the same judge as well.
Yes, I mean, I don't know what case you think supports that. I mean, I think both Kumar and Guilford address quite similar circumstances, which I think deploy the practical result of, well, it would be silly if we got a denial of summary judgment and a grant of summary judgment for us to do anything other than figure out which one is correct. It would be silly because if we say, well, Judge Irving, you should have abided by law of the case and let this go to trial, then we might later hear an appeal and say, yeah, all of this was inefficient or this was insufficient as a matter of law, so judgment in favor of the defendants anyway, and that would be an extraordinary waste of judicial resources, plus it would seem awfully silly.
Well, Judge, we don't disagree, as I said, that this court can reach the merits if it wants, but the court has in multiple decisions held that the law of the case alone was a basis for reversal and it reversed on those grounds.
When the ruling was not something that was subject to appeal? When the initial ruling, so, you know, you can appeal a denial of qualified immunity, which I think is the key case you've got. You can say, well, they didn't appeal it, so, you know, it's final enough and we shouldn't look behind that. Of course, a denial of a grant of summary judgment is not immediately appealable. So this case seems to fit into that bucket of things that we have, so far as I know, we've never applied law of the case. So what's your best case for an order that was not appealable on its own, that a judge then changed their mind on, or a new judge went the other way and we said, no, you can't do that?
We have several, I mean, the Kaplan v. Pointer case, which is cited in Kumar, is cited as a butsy, but we think that it's actually reconcilable with Kumar to recognize that a denial of summary judgment can be law of the case if it's sufficiently final. But in Kaplan, this court held that a prior denial of summary judgment was law of the case, quote, precluding the second judge from ruling anew on appellant's subsequent motion, end quote, and reversed without reaching the merits.
Can I ask, is finality, the word you're using under law of the case doctrine, the same, as it is for the final order rule?
It is not, Judge, and we think that that's established in this court's cases, including, I believe, the Kaplan case, but where the court said, I think that's actually where the court said, I'm sorry, the Kumar case is where the court said, look, a summary judgment order is not interlocutory. Obviously, it's not final for purposes of appeal. But then the court went on to recognize that it could be law of the case for purposes of binding the court, the same court, that is dealing with the case.
Okay, but it doesn't have a different definition of finality, or does it?
The rule that we're citing is from PPP, which is a 3-factor test, and they use the sufficiently final language. But I think that the case that I just mentioned makes clear that the finality for purposes of appeal is distinguishable from sufficient finality. And just to give a few other examples, in PPP itself, that involved a prior denial of a motion to dismiss, which is the Aaron Haft case also was a motion to dismiss. The Kritzidemas
I'm
case.
sorry, I'm still on Kaplan. So Kaplan was the absolute immunity case. That was an appealable order when it was denied. I mean, so
yes,
case number one falls into not the thing that I'm looking for. Where's one that could have been appealed and wasn't? So what's your next attempt?
Sure. In the Dugan case that we cite, which is 554 A second 1126, it's from 1989. The court said that that the prior denial of summary judgment was not law of the case because the first judge never intended for it to be final, but rather said he had not been given enough facts.
All right, so that's not quite one either, though. So that's one where we said, we said a reason why we wouldn't apply law of the case. It doesn't mean, but absent that, we would have.
Yeah, I think that this court has repeatedly applied or indicated that the law of the case could apply to a denial of summary judgment, and we've cited cases for that provision. I understand your point, Judge, that that the case involved the denial of qualified immunity, but
Unless my colleagues want to stay on this, maybe it's. I mean, I would at least think as a discretionary matter. I still find it kind of silly not to address which order is right. So it might be more helpful for me,
of course.
not to cut any questioning short if you guys are still interested.
You don't really disagree that it's discretionary, is that?
We agree that the court can reach the merits, yes, Judge. With respect to contract, there was an oral contract, as Judge Edelman found. I don't think Judge Irving disagreed that there was an oral contract. All he looked to instead was whether it was invalid for lack of consideration or invalid under the statute of frauds.
I'm not sure I entirely appreciate the point that there was a contract. It has seemed to me that it's hard to find in this record that the parties, that there was a meeting of the minds on all the material elements of a contract.
Mhm.
I have tended to think that your strongest arguments are in the area of unjust enrichment and promissory estoppel, rather than on the existence of a contract. How do you respond to that?
Sure, Judge, and I'm happy to skip to the equitable claims because I know my time is limited. But with respect to the contract, we would point to, of course, the September 18th Paris meeting where the parties had, and there's testimony in the record from our client that the parties had an oral contract at that time, met the minds, and then he sent an email subsequent to that. I think it's JA 349 that attached the term sheets that he said referred to what our discussions encompassed. And
There's no indication that the other side, other than well, I guess maybe you're right. Maybe your client's testimony suffices to get over that hurdle. I was thinking that there's no evidence that the other side agreed that they had ever minds met.
There are subsequent emails, Judge, including for, I believe, Mr. Wong, one of the defendants who our client was interacting with, said, got it, will revert. There was a subsequent email where when Mr. FAROOQUI followed up, he didn't dispute that it was indeed their final discussions. These are the things that Judge Edelman relied upon to find that there was sufficient evidence. And there's, I believe, the Asfaharji case from this court where it's made clear the corroboration is not necessary in the first place. We think the record's pretty substantial here written wise, including our client's testimony that there was an oral agreement. This was a term sheet that was supposed to reflect those terms, and that Mr. Wong essentially strung our client along for several months and then cut off communications because he didn't want it to actually fulfill his obligations.
Do you agree that by the terms of the agreement as memorialized and emailed over, that's supposed to have been memorialized in the September 18th meeting, that agreement could not have been completed within a year? That all the terms of the agreement could
Yes,
not?
we agree that.
Okay, you agree at that point. So you're relying strictly on a partial performance.
Yes, Judge.
And then what's your response to, I mean, I traced this, the evidence must be unequivocal of an agreement line back to, I think it was an 1897 case of ours that's cited in some of the cases that are cited. It does seem to be it does seem that we have a pretty firm requirement that the evidence that the partial performance would not have taken place absent the agreement. There needs to be unequivocal evidence of that, like sort of the fact that the person is performing shows you that there is an agreement, which is very hard. If that's the right test, it's very hard for you to prevail on a breach of contract because the post-September 18th partial performance looks a lot like the pre-September 18th performances in anticipation of reaching some agreement. So do you think I'm getting the legal test wrong, or do you think you just can surmount that legal test?
No, I think first of all, Kresge is, as Your Honor mentioned, is an older case. That case, I think, stands for a basic principle. There was a tenant who was promised a tenancy for years and also repair cost from the landlord if they would take over a business from an existing tenant. And the landlord said there was an oral agreement, and according to the tenant. And the landlord said, well, there's not an oral agreement here. You just have a tenancy for years. And this court said the specific language, and I think it's important to stick to the specific language, is that the question was whether the oral agreement was, quote, not only inconsistent with the contract setup, but also inconsistent with any other. I think that's really important language because the facts of that case were whether it was one contract or another. Was it a tenancy at will, or was it a tenancy for years? And the court said, look, in this instance where there is a possible other contract, we will require very stronger evidence, but we think that that's met here because there's no way that this potential tenant would have made repairs and bought a bar room and bought the license and done all this stuff if they were simply just a random tenant at will. In addition to that, we do cite in our brief the Interdonato case from this court in 1987, the Patrick v. Hardesty case from 1984, the Zanders case from 2009. All of those dealt with partial performance, reversed summary judgment, did not mention the test of Kresge. So I would say if you're going to reconcile those cases with Kresge, it's the reading that we're proposing.
Yeah, I mean, when I said tracing back to 1897, the case I'm looking at is McCartney versus Fletcher, which is what Kresge cites, and a few of these other cases cite when they use this unequivocal language. You know, we are bound by earlier precedents rather than latter ones on this court. You know, we have one panel doesn't overrule another. So if we said something binding in 1897 and we've never taken it en banc, we're stuck with it. I don't expect you to know this case off the top of your head.
I might.
But I will say, as I read it, it sounds to me like we really disfavor oral contracts. And, you know, that's why we have this 1-year limitation. To get around this through partial performance, you really need a performance that sort of demonstrates all the various terms as if somebody had started doing some employment and gotten paid for the first couple weeks and then stopped. It almost more like a quantum Merowith theory almost. So I don't know. I think the contract claims might be a little tough if you're not disputing that this couldn't be performed within a year. Can we talk about the equity claims a
Sure,
little
of
bit?
course. With respect to the equity claims, I think that those are, perhaps as Judge Glickman said, easier. There is.
Did I
there
say
was-
easier?
Maybe you implied it, Judge. With respect to those claims, I think that they're perhaps easier. I don't think that anybody has ever disputed that there were substantial, sizable benefits conferred by our client on the defendants. Mr. Zhou has said that he didn't receive them personally. He received them in a capacity as shareholder only. We deal with that in our brief, and Judge Edelman rejected it, and I think correctly. I don't know really what the actual ultimate argument is that the equitable claims don't work. First of all, for quantum Merowith, to the extent that's the claim you're talking about, Judge Irving cited the statute of frauds for the reasons I just said. We don't believe the statute of frauds applies here. Secondly, he said he looked at the same evidence as Judge Edelman had looked at, and he said everything that you did was in anticipation of a future business opportunity as a matter of law. I think that the record sharply contradicts that. There were offers of equity going back to 2015, different types of equity, but it's been very clear for 3+ years in this history of this case where there were negotiations that the defendants were looking to bring plaintiff in with equity for sweat equity for his compensation. And that is, that is not at all like Bloom Garden, which is the principal case that I think that Judge Irving was relied upon, where it was, somebody who set up a land developer with somebody who was going to fund the land and said, I don't know if I want money from anybody, like I'm just here. That's obviously, at least as of 2015, according to the record, that is very clear, and it's supported by the fact that the defendants consistently requested plaintiff services in connection with their business. I think that it's very clear that he was not just working for a future business opportunity, whatever that means. He was looking for the equity that he was going to be promised.
So I know appellees will have an opportunity to dissuade me, but I'm also of a similar view that I don't understand why at least an unjust enrichment claim wouldn't survive given the course of conduct between these parties. and sort of the clear expectation that payment would ultimately be made just because, you know, maybe terms weren't ultimately agreed upon doesn't get you out from under an unjust enrichment theory. So can you explain to me how your various equitable claims intersect? So part of me thinks, well, one's as good as another, right? Unjust enrichment, promissory estoppel. I know, you know, we can walk through the elements of them, but what's part of me is just sort of like, are you going to whittle these down to one? Do you think they all survive? Do you think that some are on stronger footing than others? What do you think your strongest equitable claim is?
I think, first of all, Judge, we think they all survive, as Judge Edelman held. We think the quantum merit and unjust enrichment claims are quite similar. I think the measure of damage is different insofar as quantum merit, I believe, looks to the value of the services, whereas unjust enrichment looks to the value of the benefit retained. We've presented evidence that we believe should be reinstated in this case as to what the parties offered and counter-offered and ultimately agreed upon that shows real-time what they thought that was worth. You know, to be candid, Judge, I think the promissory estoppel claim's a little bit harder insofar there were lots of promises over the years, but they were sufficiently definite over the years. There were promises, as I've said, of equity throughout the years, and there were consistent walkbacks and assurances that this was going to be okay and you should continue to, and it ultimately culminated in, according to us, an oral contract rather. So I think all of the equitable claims, promissory estoppel claims should prevail. I think our oral contract claim should prevail as well, but I understand the doubt there. I know I'm over time, but I'm happy to address any other issues on initial.
I guess we should at least hear from you on the preclusion of the expert.
Yes.
I'm more interested. I'm not so interested in Campbell.
Yeah,
but the expert.
Yes. So the expert that we presented was CPA Taylor Ehrlich, who presented 3 scenarios of damages. One was based upon the initial offer from the defendants. The second was the same day counteroffer, counterproposal from our client. Very similar, but had some differences in terms of the amounts of equity and perhaps fees. And then ultimately the oral contract. Mr. Ehrlich looked at essentially the big thing that our client was getting was a percentage of SILKWAVE, which was kind of the overarching company that was going to really run this. And it was, I think, ultimately 4% is what he was supposed to get under the contract. And Mr. Ehrlich performed a total enterprise value analysis of what that was at the time he was supposed to get the equity, looking at independent third-party appraisals that, including defendants themselves, using Deutsche Bank, for instance, had done. And he said, here's what I think that these are worth. Judge Ross, in a motion in limine, a very short portion of his order, he excluded this for 2 reasons. We think both are wrong as a matter of law and just looking at the record. The first was that he said that for quantum merit, unjust enrichment, and fraud, those damages theories wouldn't work because Mr. Ehrlich had not done an independent assessment of the value of the work. I don't know where that came from. It wasn't said anywhere. I understand that the legal standard is the value of the work comes into play for part of this, but there are tons of cases. I would cite the court to the Espelliot DC Circuit case that we cite. In that one, the DC Circuit reversed and said that the jurors, where the plaintiff claimed fraud, the jurors could be guided by the value of the contract, and they'd be free to consider as some evidence of that value that the parties themselves had agreed that the appellant was to receive $600 per month. That's at 383 F second 220. As for the quasi-contract unjust enrichment claims, the restatement third of restitution, section 49, which we cite, is very clear that what somebody offers and what parties look like they've agreed to is fair evidence of what the benefit, which makes a lot of sense. And especially in a case like this, according to the restatement, where want of formality, the standard example being a contract that fails to satisfy the applicable statute of frauds, is the reason.
So could I, one reaction I have is, I totally agree that sort of what parties are willing to pay for the pass is, you know, especially after fairly sophisticated parties, after what seemed like a fair bit of negotiation, is probably a good approximation of what the value of the services rendered and the benefits conferred to date have been. Why do you need, what is the expert doing? I mean, that's an argument you can make to the jury, right? But I suppose the expert is just quantifying in dollar amounts the value of the various things that you say were contracted for. Is that basically it?
Yes, Judge. He did a very fairly substantial analysis based upon accounting, looking at the fair market value of the company. This is stuff that, first of all, I think Judge Ross's motion in limine order, if left to stand, defendants will absolutely argue that we cannot rely upon those offers and counteroffers and contracts. So that's going to create an issue. And I think that that's simply wrong as a matter of law. Second, you know, even if we could rely on the offer, counteroffer, and contract, it's going to be a lot less clear and harder for our client to get up there on the stand and say, let me explain this to you, than the expert who we paid for. And frankly, I think we have a right to present our case in the most persuasive way. The only other issue that Judge Ross identified was that he thought that the assessment by Mr. Ehrlich, the expert, was quantifying compensation both backward and forward looking. That's incorrect. If you look at the contract terms or the written document that was supposed to codify the oral agreement, it's very clear that the equity that Mr. Ehrlich quantified was in consideration of past services performed. And then there are future components, including the fundraising that Mr. FAROOQUI was going to do, that were not taken into account. To the extent that Judge Ross thought that Mr. Ehrlich was taking those amounts into account, that's just not correct.
Okay, thanks so much. We took up all of your time, but we'll give you a couple minutes on
Thank you.
rebuttal.
Your Honors, we've agreed to split the time equally, myself and Mr. Schwaber. Good morning. May it please the court. Vernon Johnson from Nixon Peabody for 6 of the appellees. Charles Wong, and then what we call the entities, there are 5 of them: CMMB Vision Holdings Limited, SILKWAVE Holdings Limited, Chai Capital Holdings Limited, New York Broadband LLC, and New York Satellite Holdings LLC. It seems obvious to me that there are certain areas that the court is focusing on, and I'll try to go through what I heard earlier during the appellant's argument and focus on a number of those things. I think it's helpful to put things a little bit in context in terms of what was going on here. The lawsuit that was filed in October of 2019 alleged a 7-year relationship with services rendered, it was claimed, by Mr. FAROOQUI as agent of the defendants. And the term agent wasn't used colloquially. It's actually used 51 times in the first amended complaint, almost once on every page by average. As it turns out, he was hanging around this transaction, suggesting that he would invest, suggesting that he could help. What it actually turned out was that he was helping the other side, Mr. Samara, the party that was adverse to my clients, and feeding them information about negotiating strategies and what our clients were intending to get, hoping to negotiate. And he was paid. His original premise is, I did all this for 7 years. No one paid me anything, and I spent over $750,000 out of pocket of my own money as part of this. Well, it turns out he actually was paid by Mr. Samara. His own expert calculated that amount as almost $3.8 million during that time. And in terms of his out-of-pocket expenses, his expert could not substantiate anything, zero. Not a single dollar of out-of-pocket expenses. That's what he was doing for 7 years. And you'd immediately, I think, ask yourself, how did it get to this point after 7 years? And we argued in the alternative below, and it was always asserted as a defense, that the claims were brought outside of the applicable statute of limitations. And there were many claims. There were 8 counts in the original first amended complaint. We're down, I think, to 5 now, and maybe we're only down talking about the equitable claims. But the picture that was painted, and it's undisputed, is much different than what Mr. FAROOQUI would have you believe, that he conferred this benefit, that he provided valuable services, and he's somehow entitled to something for that. Let's talk for a moment about unjust enrichment and quantum merit. And the damages under both theories are different. Unjust enrichment is a benefit given to the defendant that the defendant is retaining wrongfully. Quantum merit is the value of the services. He didn't prove either one of those things. What he did was he had an expert, which was his sole evidence of damages, Taylor Ehrlich, and that expert looked at one isolated part of what the parties were discussing. That is,
I mean, can I stop you? Because, usually, a party can get to a jury on establishing that they have been damaged, and that they've suffered some monetary damages. To say he can't perfectly quantify it, well, that seems like a thing you can present your own expert, if you want to say the value of these services were in fact nothing. We've retained nothing of value or minimal things of value. But he's got very strong evidence by virtue of what seemed to be years worth of we'll make you whole, we'll pay you for all your services. Discrepancy, there are differences in September 2018 about what exactly was agreed to, but it does seem to be some, they were close, and the value of what he's going to be paid for is somewhere in the millions. So what? So he can't pinpoint it very well? That should be a reason to grant summary judgment for the defendants?
well, an element of the substantive claim is the damages, and he doesn't have any evidence on that at all.
I don't know. I suspect one very good piece of evidence is that your clients at one point seemed willing to compensate him to the tune of millions of dollars.
That's not really the case. What
I mean, there aren't facts in the record that a jury could credit to that end?
there are facts in the record where the jury could say they were discussing for years the possibility of certain arrangements, and there also are claims going back to 2014, 15, 16, that promises were made and broken, and that payment wasn't being made, and there was a complaint by Mr. Farooqui about that. So we have some serious statute of limitations issues that I think can't be overcome. But in terms of the actual, what is the actual evidence
You
of?
guys raised statute of limitations as an affirmative defense?
Absolutely, we did. In the answers, it's in there from the very
And
beginning.
was the lulling doctrine discussed when the trial court, did you guys talk about the lulling doctrine? The lulling doctrine is sort of payments coming, don't worry. And that can extend the statute of limitations. What about that?
They didn't argue that
Uh-huh.
in response. What they retreated to, and I think this is important in explaining how Judge Irving ended up where he did in January of 2024. And I don't know if I need to waste time on the law of the case. I
No.
perceive not, but I would, if I have to, I would cite your honors to the Guilford transportation case. That pretty definitively says the question, as you pointed out, Judge Deal, is did the judge reach the right result, regardless of whether there was law of the case stating otherwise. And there are many cases that have said that. There are no cases that I know of where this court has reversed and said you are not allowed to revisit summary judgment because another judge denied it.
Well, Kaplan is one. Kaplan was an absolute immunity case.
The qualified immunity case, which I do agree is totally different. You have an immediate right of appeal on that. We were allowed to rebrief summary judgment and we focused on the statute of limitations. They then changed their contract claim and their other claims. They focused almost exclusively on September of 2018 to December of 2018. That's not what they did before. In the joint appendix at pages 575 and 576, you can see their answer to interrogatory that they now say only related to promissory estoppel, but that's not true. Their contract claim was every single thing that happened over 7 years leads us to believe there was a contract. When they responded to summary judgment, when we were allowed the opportunity to brief it before Judge Irving, they said, we're only suing on one single contract, and it's this oral contract from September of 2018. Therefore, they didn't say he was doing all these things before that as part of the contract or as part of a reasonable expectation of payment. And that was fatal to their claim that any of the work that he was doing before September of 2018, which is really everything he did. He didn't do, there's no evidence he did anything after that. But he gave up his claim that he had been working under expectation of payment or under expectation of a contract or under some promissory estoppel situation because he didn't want to get time barred. And he said September of 2018, you know, I filed suit in October of 2019, so I clearly am within the statute of limitations. When he made that decision to change his claim, then he's giving up anything that was before that, which previously was the basis for a lot, if not all, of his quantum merit, unjust enrichment, promissory estoppel, and a good part of his breach of contract claim. And I think that's important. And when Judge.
Sorry, I just don't think I quite followed. You're saying at some point he's asking the court to discount the pre-September 2018 conduct in relation to his equitable claims?
He's saying that he's not suing on that. He's suing on what happened in September of 2018.
He's suing on that too. I mean, why can't it be both?
Well,
I mean, I thought the equitable claims were based roughly all pre-September 2018. I don't, by saying, and then we had a contract in 2018 that you need to perform and you haven't paid me on, I don't see why that would disavow the equitable claims. They're just alternative arguments.
well, if they're in the alternative, he said there was an express agreement, which of course is totally inconsistent with the equitable claims, but he lost the
I agree.
ability.
He could definitely only win one. But I mean, the jury might not believe him. I mean, it's an oral contract. So he says, look, we really did have an oral contract and I want that to be performed. But if they don't believe me because you guys are saying no, well, at least I've got these equitable claims that, you know, we were sure close and they were promising me compensation for years and I did all this stuff. We see that all the time. I mean, we do have cases, you can't recover on both theories. You can't do contract and unjust enrichment, but pushing them in the alternative is what any savvy litigant would do.
Well, and sometimes you have to make an election at some point, but.
Sometimes, I don't think this time.
Well, if he's not saying that there was a promise and not saying there was a contract until September of 2018, he didn't have a reasonable expectation of payment or compensation. He was
I don't
working.
understand that, counsel. Look, the terms were not concrete until September 2018. That's his theory. But the whole time we agreed that I would be compensated fairly for the work that I had been performing for years. And those were the promises that extend, you know, I don't know if you want to say back to 2015, 14, or 12. Somewhere in there. There's no inconsistency in those views. That's a totally coherent thought.
I think they are inconsistent if you look at what he argued. The other thing is, in terms of what his remedy would be, he didn't put on any evidence of the value of his services or the value of the benefit. Typically, in a case like this, what you would see is you would say, I worked for 7 years. I spent 500 hours a year, 1,000 hours a year. I flew all over the place. I didn't get paid for anything. My time is worth an hourly rate of something, and you'd have some calculation. We have nothing like that here. We have an equity.
It just doesn't sound like the judge's ruling. I mean, it sounds like you're inviting us to rule on some alternative ground. You know, what Judge Irving says is not, he doesn't make a ruling that I'm granting summary judgment because of some evidentiary deficiency in establishing the amount of damages. And then, you know, that's really not what the briefing was about either. Instead, what he says is quite curious. It's sort of you don't, mere negotiations don't entitle you to the money. It's sort of a totally an opposite principle where in cases where the performance hasn't already begun, that's all well and good. But this case doesn't look anything like that. This is a case where negotiations are going, at least if you believe Mr. Farooqui, as a jury, I think might, that the performance has been ongoing throughout those negotiations. So I don't really understand Judge Irving's reasoning, and I'm not really hearing you defending it.
I would defend it vigorously. I think Judge Irving did a deep dive into the entire record in the case, and he said he read it. What he's looking at and parsing is he's saying, if you didn't have a contract until September of 2018, what were you doing in all the years before that? And he looked actually, and he quotes Mr. Farooqi's deposition testimony about what he was doing at various times. He didn't have a commitment from anybody to pay him anything. And he was continuing to be involved in the transaction, obviously because he thought at some point there'd be an opportunity for him to get a benefit. That is far different from saying he was operating under an expectation, a reasonable expectation of payment, or he was conferring a benefit. I don't even know how we would determine that, because he was actually, remember, getting paid and reimbursed for expenses during this whole time by Mr. Samara, which he didn't
During this whole time?
during the entire time.
Can you tell me what, if, to the extent that is an undisputed fact, can you point me to where it is?
It's in the Taylor Ehrlich expert report, with the plaintiff's appellant's
As
expert.
he's being
report.
paid, continuously from 2012 to 18.
Yeah, and there's actually a table. It's one of the exhibits. I can't remember which one. Maybe it's Exhibit 5 or Appendix 5, has a complete tabulation of how he got to his calculation of 3.7.
He's discounting amounts that he's saying Samara, that Mr. Farooqui said Samara paid him. Is it something like that?
He counted up everything that he calculated based on the records given to him that Mr. Samara paid Mr. Farooqui. And incidentally, there was a $2 million loan that we were aware of too in the evidence. And conveniently, Mr. Ehrlich had a private conversation with Mr. Farooqui where supposedly Mr. Farooqui told him, oh, well, I never got that loan. So he discounted that. That's not part of the 3.77 million, but there is a table in the expert report where he adds all that up and substantiates the calculation.
If I could say, accepting all that as correct, what are we to make? Maybe you've already answered this, but I don't think so. What are we to make of the various, the evidence, the testimony, that the various assurances that Mr. Wong, or perhaps some other people as well, made to Mr. Farooqui that you will get paid, we'll take care of you, whatever. The fact that that Mr. Farooqui may have gotten compensation from Mr. Samara and may have had a conflict of interest or may have been serving two masters or whatever, that's all very interesting. But I'm wondering what we're to make of, nonetheless, this evidence in the record that for a long period of time, it would seem, Mr. Wong was, and others perhaps, were assuring Mr. Farooqui that his services were valuable, you will get paid for them, we'll work something out for you, you'll get some equity and so forth. What are we to make of that?
Mr. Farooqui, in his own words, quoted by Judge Irving in the summary judgment order, made it clear he was working without any commitment from anybody, hoping to get something in the future. And the most we can make out of that, Judge Glickman, is the statute of limitations has run on these claims. If he was getting promised for years, that going back to 2012, 13, 14, and promises were being reneged on, and he affirmatively alleges that,
Well, is that
the statute is run.
Well, statute of frauds.
The statute of limitations, and there is a statute of frauds
I
issue.
mean, I see the statute of frauds argument. I can sort of think that as long as he continues working on and they all understand, we've made you a promise or an assurance, and he continues working, it's a little hard for me to see that the statute of limitations runs before the end of the work. I mean, suppose they said to him, look, when this is all done, it's going to take years, but when this is all, we'll deal with statute of frauds later, but this is going to take years, but when this is all done, you're going to love us and we're going to love you because you're going to be our, partner in this venture and you'll get a lot of the rewards of it. I don't know that, does the statute of limitations run until we get to that final endpoint when the payment is due?
I think there are many times where a claim accrues because there were different stages of the transactions where transactions were worked on and closed. The Boeing transaction and the SILKWAVE transaction and all these things. And there are direct allegations in the complaint that promises were made in 2015 and reneged on, and promises were made in 2016 and reneged on. Those claims accrue at that point. He could have filed a lawsuit at that point, and he's time barred now from coming back and making a claim. And he also is barred under the statute of frauds. The statute of frauds in DC is very broad. It prohibits any suit, any claim for an agreement that couldn't be performed in a year if it's not in writing. And it's undisputed here. I'm glad we've heard that definitively, that this could not be performed in 1 year. And there isn't any part performance. You're absolutely right, Judge Deal, about the case law. It is a high burden in DC, and I think it's illustrative of the suspicion that the DC courts have over oral contracts.
Does your answer apply to the unjust enrichment claim?
I think it does. The statute of frauds doesn't say, except for equitable claims, other claims are barred. I mean, they're making.
Yeah, it's a question of the accrual time, I think. Well, all right, go ahead.
It's a complete bar to a claim like this, whatever theory they try to package it under. And
That doesn't make any sense, because the unjust enrichment claim doesn't depend on the contract. So, I mean, the whole statute of frauds, the theory behind it is we just don't believe, especially you might say with such sophisticated people with this much money at stake, that anybody intended to be bound absent a writing. So we want a writing, and if it doesn't exist, we are just going to say we don't buy it. Unjust enrichment, you don't need a writing. It's all equitable. Has a benefit been conferred in a way that would be unjust for your client to retain the benefit of? And if so, then remit. There's the statute of frauds. I mean, conceptually, it just seems totally irrelevant to me. Do you have any case that any court has applied the statute of frauds to bar an unjust enrichment claim?
I can't tell on an unjust enrichment claim, but I know that it's whatever he's talking about, especially the quantum merit claim, but the unjust enrichment claim too, derives out of some claimed contractual relationship or hoped for contractual relationship. It's a form of a benefit. Every single thing that he's claiming is related to whatever he says the contract was in September of 2018. Every damage, every element of his recovery flows out of that. He's not claiming that he gave some benefit in terms of what would it be? A monetary recovery or a business accomplishment that has some value that can be elucidated? He's not claiming that. He's claiming, I was supposed to get this stock and here's what it's worth, and that's the unjust enrichment.
I think he's saying I benefited you guys to about this tune, and one good piece of evidence of that is that you now are you agreed to remunerate me, you agreed to enrich me to that same tune, and that shows you how much the value of my service is and how much you guys have been enriched as an evidentiary point, even if it was never solidified. Okay, so what? It's not a contract until it's signed. Let's just say that, let's take that position. So there's no breach of contract claim, statute of frauds applies. What's wrong with the theory that I just laid out? But I have done all this stuff for you. We all agreed we would come to some terms. You would pay me some fair amount. And the best indication of a fair amount is the thing that we almost agreed upon.
We still have the statute of limitations issue
Yeah,
because
I mean, you could stop him from going back more than 3 years. But unjust enrichment isn't all or nothing. We often just say any enrichment prior to those 3 years would be barred, but then we need to get into a lulling doctrine, which hasn't been briefed. It hasn't been ruled upon. I appreciate you're telling me, I mean, I can go look, but nobody's ruled on the statute of limitations and nobody's briefed it. I don't know why we'd rule on that in the first instance. It's not what the trial court did.
it has been briefed on appeal. It was briefed below. It wasn't the basis for Judge Irving's ruling, but obviously this court can affirm for any reason, even if it wasn't the reason that the trial court relied on. It's been briefed on the appeal in our brief and in their brief. And I think the accrual is, as a matter of law, many years before, well, more than 3 years before the complaint was filed in October of 2019.
Remind me, did Judge Irving explain why he wasn't addressing statute of limitations, given that that was one of the things he claimed he wanted to hear from the parties on, right?
I don't think he really explained that. I think he went by, if you read his order, He said he went back and looked at the entire case. He also had the benefit of two very extended hearings where he asked everybody all sorts of questions about the case, including probing Mr. Farooqui in detail about the theories he was relying on. And there were many changes and many concessions that were made in those discussions about what was going on in terms of the underlying facts and what their claim really was going to be based on. I mean, in the end, when they were ready to go to trial, they only listed three witnesses. One was the expert. And I don't think, we haven't spent a lot of time on the expert. There's no abuse of discretion in what Judge Ross ruled on in limiting either the retained expert or the lay expert, Patrick Campbell, in this case, and no abuse of discretion was argued below. But there's not a, there's no reason you couldn't rely on statute of limitations to dispose of this case. It has been fully briefed, and that briefing's available. And it's not unusual for this court to, even on summary judgment, affirm on different grounds than the trial court relied on. But I don't think, Judge Deal, there's an unjust enrichment claim on these facts under these circumstances, given the undisputed evidence that is before you. I mean, I don't know how you would figure out what the benefit supposedly was, even if the claim were timely. And I think there's no way the claim is timely, because by his own admission in the complaint, he started doing all these things that were such great benefit in 2012. And he didn't sue until 2019, 7 years later. He's never claimed he was lulled into inaction or that he reasonably relied on some sort of renewed promise or new promise. He never made that argument. So I just don't think there's any basis for these claims to go forward. And Judge Irving was quite correct in granting summary judgment. We would ask that the ruling be affirmed. I'm certainly glad to answer any other questions the court might have.
Thank you.
Thank you.
Morning, may it please the court. I'm Jeff Schwaber, and I am with the law firm of Stein Sperling. I'm here representing just one of the appellees, Mr. Zhou Qinghe, who probably for the benefit of all of us with pronunciation challenges throughout this case has been referred to as Mr. Zhou. With the court's permission, I'll refer to him as Mr. Zhou. Mr. Zhou, we believe, was brought into this case for one obvious reason, as a deep pocket, a gentleman who was there to either resolve the case or satisfy a judgment if the day ever came. And from the very outset, and we weren't initial counsel, but from the very outset of the defense of Mr. Zhou in this case, there was the question, what are your claims against us? How are you going to get past corporate form? What are the damages against Mr. Zhou, who doesn't speak English, who you haven't communicated with or negotiated with, except very sparsely in a couple of occasions over 7 years peripherally? And the initial interrogatory to the plaintiff here was state all facts and identify all documents supporting any claim of damages and the amount of those damages, including but not limited to the damages identified in the complaint, etc. That answer was, and we briefed it, was very obtuse. It was very evasive. It was never, ever supplemented throughout this case. And then came the deposition of the appellant, Mr. Farooqui. And here at the joint appendix at page 667 is an exchange I had with him in his deposition. Question, did I hear you correctly that those two agreements, meaning what we'll call the Paris agreements, constituted the terms of the compensation that you believe you were entitled to from Mr. Wong? Answer, yes. the terms of compensation I was entitled to? Yes. Question, going backwards and forwards? Answer, going backwards and forwards. Correct, yes. These agreements, which were in September to September 2016, make no mention of Mr. Zhou, have no signature line for Mr. Zhou anywhere on them. And the agreements, however, and we'll talk about Mr. Ehrlich, who did 3 different damage theories, not because he had 3 different theories of damages, but because it's unclear which agreement between the offer, counter, recounter was going to be used ultimately as the terms of the deal. None of that had anything to do with Mr. Zhou. Mr. Zhou is an investor, he's a lender, he's a corporate officer. He may be any number of those things, but he is not a party ever to any transaction. He is not a party in his individual self to any negotiation. And he was asked, plaintiff was asked 6 ways to Sunday in this case, what are you claiming Mr. Zhou did? I will, in the interest of time, and I'm happy to answer any questions, kind of dispense with the straight contract theories and go to the unjust enrichment and the quasi-contract theories, the quantum Merowith theory. But the relevance of the contract is that, as I just read to the court, the contract, or what I'll call the contract, the September documents, the 3 of them, constitute the terms of the deal, the only terms of the deal, backwards and forwards. And while that doesn't necessarily in its own right preclude an alternative theory of quasi-contract or unjust enrichment, here, the facts of this case, as fully discovered and fleshed out, are that there are no separate terms. So the terms of the work performed by Mr. FAROOQUI and or the terms of the benefit conferred on the defendants all flow out of those by his own words. They flow out of it temporally and they flow out of it substantively. There are no other terms. And the other thing that I think is a kind of a death knell to the claims is he says backwards and forwards. So these were terms of what his relationship was going to continue to be to one or more of these corporate entities, to SILKWAVE as it was going to go forward. None of it separately fleshed out any claim against Mr. Zhou.
Is there, excuse me, is there evidence from which a jury could reasonably find, viewed in the light most favorable to the plaintiff, that Mr. Zhou received benefits as a result of all this activity, such that one could say it is unjust that he retained those benefits because they're based not on anything Mr. Zhou did, but on the basis of what Mr. Wong and other people did?
I asked that question through discovery many times, and there were 2 kinds.
I'm glad I'm on the right track, right?
There were 2 kinds of answer. One was some amorphous, well, Mr. Zhou had this charitable notion of education, valuing education in Africa, and this satellite venture was going to facilitate and permit the kind of exposition and the development of this dream of his in the future. So since this now exists as an entity, that will confer some benefit on him. There was no articulation or separation of that. And Mr. Ehrlich, who was their damaged guy and the only damaged guy, and while I certainly agree with Judge Deal that that doesn't open and shut whether they can bring a damage claim kind of theoretically, in this case, he says there's no separation of the benefit for Mr. Zhou than the benefit for anyone else. It's to the penny the same. That's their testimony that they're bound by, and that's their testimony that Judge Irving used in striking the expert entirely as it relates to Mr. Zhou. He made a distinction there.
So, I mean, one thing Judge Edelman says is, you know, Mr. Zhou does not even become the shareholder of SilkWave until 2016. And he's engaging with Mr. Farooqui back in 2012, sort of, you know, plain evidence that he's got some personal stake in this beyond his role as a shareholder in SilkWave because it predated it. That he's being benefited personally. Otherwise, why is he enlisting Mr. Farooqi's services when he's not even a shareholder of SilkWave?
He has and this gets to the second I told you, Judge Glickman, that there were two benefits. One was this education thing, and the other is here, this notion that whether it's as a lender, whether it's as an investor, whether it's as a shareholder or a prospective shareholder in a venture that you have a relationship with Mr. Wong, you have a relationship with the satellite industry, you're looking at all this stuff. That to suggest that there's an individual benefit there would kind of eviscerate the corporate form and suggest that because I own shares of IBM stock that I individually benefit if IBM goes through the roof. Or
I'm saying the opposite. What is Mr. Zhou's interest between 2012 and 2016 before he buys into SilkWave?
Mr. Zhou,
If it's not a personal one, is the question.
In SilkWave, he doesn't. In SilkWave per se, he didn't have an ownership interest, but he had loaned money to Mr. Wong to other ventures. He had loaned money that related to the prior acquisitions that led up to that one.
Those interests were getting repaid on those loans?
It could be getting repaid on those loans, and it could be what we say, which is there was no individual interest. You know, but the only interest he would have is in supporting a venture that, in a light most favorable to the appellant here, prior to his shareholder interest in SilkWave, Mr. Zhou loaned money to Mr. Wong or to Mr. Wong's ventures, and Mr. Wong was negotiating with Mr. Farooqui, and Mr. Zhou was loaning that money. And Mr. Farooqui responds to that by saying, well, why would he loan all this money? What would be in it for him? It's not natural to loan that much money unless he has an interest. And it's kind of almost this like res ipsa notion to throw out to a jury, like, well, why would a rich guy just be giving money to a venture unless he was trying to pursue some individual interest and find some individual benefit? I suppose we can debate that theory, but in the course of litigation that goes on for years, where we're asking questions saying, what are you saying was the benefit to us? What are you saying was the benefit to my guy? Where is it? How will you quantify it? How will you articulate it? Give me the answers. And then he not only says there's no separation of the benefit, no light whatsoever between benefit to Mr. Zhou and benefit to any other defendant, but he also says, okay, well, he does have some other interests. He does have this educational project and altruistic notion, but I'm not articulating any difference. It's the exact same claim to the penny, and it flows out of the exact same facts, and there's no separate benefit. That is what Judge Irving decided defeats any potential quasi-contract claim or unjust enrichment claim against Mr. Zhou. You have to be able to articulate a benefit that was conferred at the time of contracting. So let's say September 2016, what was the benefit conferred upon Mr. Zhou? What was the work done for Mr. Zhou individually? And it's not okay to just at the close of discovery debate whether there's some theoretical way that he could have derived some separate benefit, separate from his benefit as a shareholder. And Judge Irving did spend time talking about the the corporate shield and that veil piercing in this court has very specific prerequisite requirements. First of all, it was never pled. Second of all, it was disavowed at the summary judgment hearing. And third, and dispositively from a legal standpoint, there's no unity of interest here that would permit the piercing of a veil. All there is an investor and shareholder, and some notion that if he'll benefit if the company does well. I want to, just before I sit down, mention two things briefly. One is the principal agent relationship that Judge Irving found there's no principal agent relationship here. And again, first and foremost, that was never pled, and in any event, it was disavowed, and that's in the appendix. And second of all, as the law makes clear in the Pratt versus DC case, which we cited, talks about this, a principal agent relationship cannot be established through the words of the agent alone. And here the allegation is that Mr. Wong said repeatedly, I need to go check with Mr. Zhao. And that's what would articulate a principal agent relationship. And that the law makes clear that that doesn't get you there. Finally, and I've alluded to this, the grant of the motion in limine as it relates to Mr. Ehrlich, the expert, which was in its entirety as regards counts 3 and counts 5 with regard to Mr. Zhou. And there the standard is that it has to be manifestly erroneous. What he ruled there, it's an abuse of discretion standard, but again, for reasons I've already articulated, there was no separate assessment of either value bestowed by Mr. FAROOQUI on Mr. Zhou or of benefit conferred by Mr. FAROOQUI on Mr. Zhou. He was simply lumped in and admittedly lumped together with no space between the
I
theories.
mean, that, I will say that sounds to me like good fodder for cross-examination. Not a good reason to preclude an expert, though. I mean, to me, if I'm trying to figure out what the benefit that's been conferred from Mr. FAROOQUI's services are, the terms that the parties seem close to agreeing to in terms of what is fair compensation are a pretty good measure of that. And you might say, well, they didn't separate out the work going forward, but you can look at the services provided to date, compare them to the work going forward and say, okay, I guess it should be discounted a little bit. And you guys can present your own expert, you can cross-examine their expert, and you can get into all this stuff. But like, since when does an expert need to be unimpeachable, like not subject to fair critique as a basis for admissibility? It seems to me that it's relevant evidence you would want to know. It's helpful to know the value of those terms if you're a juror trying to figure out an unjust enrichment claim. The fact that it's got its problems, I mean, don't we all? It's what experts tend to have some problems. And I mean, why is it enough that you can get into, you can cross-examine the expert, you can present your own expert, and you can hammer all that out?
I certainly understand Your Honor's question, and with all respect to my brother counsel here, Mr. Johnson, I respectfully think that question could be posed in general. The distinction I'm making is not there. It's not that, well, wait a minute, why isn't that cross-examination? And if you throw out the expert entirely, aren't you taking away the province of a jury? Here, what I'm saying is the expert, what Judge Irving said as it relates to my client is the expert, when asked under oath, and Mr. FAROOQUI, when asked under oath, what is the difference for Mr. Zhao? What is the benefit on Mr. Zhao? Otherwise, he's just an investor. Otherwise, he's just a shareholder. What's the evidence against him? And I asked their expert that many times, and his answer was always the same. No separation. I didn't do that analysis.
Sorry.
I don't know.
By the way, I take it Mr. Zhou, this may be too obvious to me, I take it Mr. Zhou was never deposed.
Mr. Zhou was deposed.
He was deposed? Oh, where did that take place?
Complicated.
Yeah.
It was 12-hour time, 13-hour time difference with translators, and it was remote.
When that position, when the subject of his benefits came up, what did he testify to?
No benefit other
benefit,
than
yeah,
in the
okay.
context of his, if the company did well, he'd do well. If the court has no questions of me. Thank
Mr.
you.
Schwaber, Mr. Trice, we will give you 3 minutes for rebuttal.
Okay, thank you, Judge. I'll try to be quick. And to go through them quickly. So first of all, contrary to my friend on the other side, Judge Irving did not rely at all on Mr. Ehrlich's opinion or lack thereof in his decision. To the extent that Mr. Schwaber is saying manifest error is necessary, it's an abuse of discretion to rely upon an error of law. We have cited multiple cases, including from the DC Circuit, saying the kinds of evidence that we presented are perfectly fine evidence. And as you said, Judge Deal, that's something they're free to pull out on cross-examination. It is not a basis to get our expert out entirely. Mr. Zhou has had an issue for some time with the fact that our expert opined as to damages for all of the defendants. With respect to unjust enrichment, for instance, that's called joint and several liability. He's free to argue that he shouldn't be liable in the first place, but if he was part of this unjust enrichment, it's basic law that he's on the hook for the amount that he was benefited. With respect to the notion that Mr. Zhou was not involved, he's not on the actual contract terms that we're going to memorialize the document. I would just direct the court to a few things. So JA 258, this is the December 2016, I believe it's an offer of equity and it's a back and forth going on before the 2018 discussions. And Mr. Wong says he has to quote, run it by Mr. Zhou. The September 8th offer that Mr. Wong and SILKWAVE make says this email is to confirm certain economics being awarded to you by me and Mr. Zhou. That's JA 443. And beyond that, when Mr. Farooqui sent his counter offer, JA 1421, Mr. Wong responded he would need to, quote, sell it to Mr. Zhou. The record is replete with evidence that Mr. Zhou benefited and had his hands all over this. As Judge Edelman found, and I believe as Mr. Zhou testified at his deposition, contrary to what we just heard, an educational benefit was very personal to him. He wanted to be able to provide the multi-band broadcasting that these satellites have to Africa and to Asia and parts of that. He thought very admirable effort, but that's a personal benefit beyond his capacity as a shareholder. In addition, as Judge Edelman relied upon, you can also see.
The thing that throws me a little bit about that argument is you would think, unjust enrichment is sort of retention of a material benefit, something that one can be, something that one could put a number on. Here's the amount of dollars, here's the value of the thing that I got. Sort of not the feel goods of having helped education across China. So like, what if you agree that that's a personal benefit to Mr. Zhou, what is a jury to do damages wise? Let's just say that's the only thing that Mr. Zhou benefited from. He needs to, the idea is you disgorge yourself of the unfair benefit and give it over. Well, I don't understand how it works. What's the number they should?
Well, just to be clear, Your Honor, the equitable claims seek compensation for the services, the benefit that our client conferred upon the defendants, including Mr. Zhou. The educational piece isn't just feel goods. It's actually in the 2014, I believe, asset purchase agreement. Mr. Farooqui specifically got a provision in there for a joint venture for educational benefits. It's described in there, and that is something that, according to the record, that's something Mr. Zhou wanted. The record shows he was involved.
Those benefits were never conferred.
Sorry?
That benefit was never conferred.
The benefit was conferred, Your Honor. The benefit was, and this is why we calculate it this way, the benefit was Mr. Zhou, despite his attempt to separate himself from this case, he financed 90% of the 45 million purchase price of this. The record makes very clear he was constantly involved. According to Mr. Wong and according to our testimony, he was speaking to our client directly. The benefits that he conferred were the satellite business that, as we see in the documents I cited a moment ago, Mr. Wong is saying, here is the compensation conferred to you by me and Mr. Zhou. That's because Mr. Zhou, presumably, and we will get the testimony at trial if we are allowed to go, will say, yes, I did approve that. And that was what I thought was fair compensation for all the things you'd given me. Now, were there educational benefits ultimately? That's post record, I don't know, but what they got was a business that they ultimately wanted, these two extremely valuable as satellite assets and sets of rights that they were going to use for these various purposes. And I think, as Judge Deal said, I think the fact that the defendants were willing to make an offer of compensation and then, according to us, reach an oral agreement shows very clearly how they valued the benefits, even as amorphous as they may seem.
I guess where I'm having a little bit of confusion. I see the argument that those were benefits conferred on the company.
Mhm.
Maybe, and maybe that's true of Mr. Wong personally. But just because Mr. Zhou is an investor in the company, I'm not sure I understand that those benefits were conferred on him. It's just as if, maybe this is so unsophisticated, it's stupid, but it's just as if he invests in IBM. And he invests a lot of money in IBM because he thinks it's a good stock. And IBM comes out with quantum, computing that, revolutionizes the field, and his stock goes up and he's a wealthy man as a result. I don't think of that as he's the person who benefited from whatever wrongdoing was involved between the company and somebody else that made it possible for him to reap the rewards. If he lends money to the company owes it back to him, but paying it back to him doesn't, constitute a benefit conferred on him by the alleged wrongdoer. What am I misunderstanding here?
Judge, I think you're raising an extremely fair point, which is that we obviously don't want to have unjust enrichment, for instance, be something that can pierce through the corporate veil and hold any shareholder responsible. This is not a case like this. This is who Mr. Wong described as his investment partner, the one who was constantly in control effectively as to the terms, as to investments. He was the one who wanted the benefits from the educational venture. As we put in our supplemental affidavit as well, he was also.
I understand the argument about that.
And if I may, Judge, to help guide, I think, a little bit, the Georgia Malone case that we cite out of the New York First Department, and then it was affirmed by the New York Court of Appeals. There's a rich doctrine there where they say, in that case, it was, somebody who was an officer, but they were directly making assurances, they were directly getting certain benefits. And the court said, even if there's not privity there, given those assurances, given this connection and the reliance, we will find that there is sufficient grounds to hold this person liable under unjust enrichment. The other case that we've cited, Judge Glickman, is, I think, the Christian v. Transperfect case out of the Southern District of New York from just a few years ago. And that was a big case where the Transperfect's two CEOs were about to split up. They had their chief operating officer, I believe, or chief sales officer. They said, please stay on. It'll be good for customers, it'll be good for employees, et cetera, and we'll give you equity. And the court said that is a personal benefit, even though, obviously the company's benefiting a lot in that situation. They might even be a principal beneficiary, but those individuals were able to be held liable in those two circumstances. And I think that they're very good guidance here.
So I'll use the word wrongdoing for the sake of a word. What wrongdoing do you claim Mr. Zhou participated in and was culpable of?
Mr. Zhou was right there alongside Mr. Wong running these businesses. He was approving, as we've said, these decisions.
Well,
and
what specific wrongdoing?
He was consistently assuring Mr. Farooqui that he would be compensated. I think we cite in the record that at Mr. Wong's 50th birthday party, he said, we will do good by you. And we see
Right doing. Well, the question is, what wrongdoing did he do?
the same, part of the same wrongdoing that the defendants on the whole did, which was to basically string our client along for 5-6 years.
Did Mr. Zhou what's the evidence that Mr. Zhou was involved in that stringing along process?
He was repeatedly making assurances that he'd do good by him. There's evidence that Mr. Wong was looking to Mr. Zhou for ultimate compensation decisions. And then it's a very fair inference in my view that he probably looked to him as well when he said, we're not going to actually give him a penny.
In other words, it's an inference that Mr. Zhou said, you're not going to pay that guy.
Yeah.
He wants too much or whatever.
Given his long-standing history throughout the record of
I
5-6
wonder
years.
if that inference is enough to get you over summary judgment.
Well, I think the other evidence here, Your Honor, is there was testimony as to direct conversations by Mr. Zhou to Mr. Farooqui that he was assuring him. There was a very, you can describe it as loans. I think it was a very weird financing process here. Mr. Zhou actually denied having paid money in connection, $14 million in connection with one of the investments, and then he backtracked on that at his deposition. So I think that he's done everything he could to try to be involved and ultimately control these companies, but then separate himself out to avoid liability, which is what we're seeing here. And this is a quintessential case for unjust enrichment and quantum merit against somebody who is not a typical shareholder. There's somebody who has been involved and has participated in the wrongdoing throughout. Unless the court has any other questions.
Thank you so much. Thank you, everyone, for your briefs and your arguments today in this big, complicated case. The case will be submitted and we are adjourned.
All right.
This honorable court is now adjourned.